Lord, my Lord, very kindly mention.
Yes.
Lord, I do not know that this type of mentioning, Lord, whether it's fair on my part. Lord, my daughter is coming back from Canada. But 5 days, Lord, from tomorrow, I shall not. Right, number 150 of today's of monthly list. But, Lord, from 21st, Lord, I shall be again coming. It can be on 21st.
Send your junior when matter will be mentioned.
I'm going.
Matter will be called on, mentioned.
I'm
Well, may I be permitted to mention that transfer matter which I have mentioned earlier? The difficulty is that due to the change of determination, I have inquired from your lordship's officers that the file hasn't come today since it was lying in book number 19, and possibly that was not traced yesterday also. Lordship, can it be placed tomorrow, Lordship? Because urgency is there, Lordship. I will be,
Let the file come.
I will try to ensure the
Let the
file
file
is
come.
today.
Let the file
If it is come, Lordship, kindly place it tomorrow so that it can be taken up, Lordship. The only I have
When
some urgency.
you mentioned the matter previously, then the mentioning was allowed. What was the direction I gave?
Lordship, today matter to appear today, because earlier your Lordship had,
in the supplementary list.
yes, my Lord.
This was a direction.
Yes, my Lord. On Friday also it was
Supplementary list.
direction was there.
Huh? So if file comes tomorrow, it
Yes,
will.
yes, my Lord. Can be grateful.
But upon service, I'm approaching your lordship, my lord, for inclusion of a motion matter in list.
This is not the day for mentioning unless it is urgent, very, very urgent. Mention on Monday for inclusion. Call the list.
Item number 1.
For the petitioner. Lordship, in this
And
matter,
for the commission.
there is a small correction, Lordship. The name of the petitioner,
Correction. Yes.
the name of the surname of the petitioner is Chakraborty. BAR-TTY. Should be BAR-TTY instead of BAR-TY.
BAR-TTY.
Double TY.
Issue. Matter has come up in the list for correction of the order dated 2nd April 2025. Stop. In the cost title of the order dated 2nd April 2025, surname of the petitioner shall be read as Chakraborty TTY instead of Chakraborty. Or a কাজ করো, name of the petitioner shall be read as Sukhendu Chakraborty BARTTY instead of Sukhendu Chakraborty CHAKRABRTY. বুঝতে পেরেছো? এখানে শুধু একটা টি বসবে। Next paragraph. Department is directed to incorporate necessary correction. Stop. This order forms part of the order dated 2nd April 2025.
Grateful.
Item number 2.
This is the interest on gratuity matter.
I'm for the state respondents, my lord.
Interest on gratuity matter, it will come up under the heading hearing, under the heading appropriate heading in the monthly combined list. List the matter under the heading interest on gratuity primary. There is a
Primary, my lord.
একটা heading আছে তো আলাদা interest on gratuity the primary. The appear under the heading interest on gratuity primary in the monthly combined list of May 2024.
Actually, may
2025
the affidavit of
on the next date.
Item number 3.
My lord, I'm for the petition number. My lord, this is the affidavit of service and my deficit court fees. My lord, petitioners participated in the 2009 selection process conducted by the District Primary School Council, Malda. My lord, advertisement is of August 2009. The written examination was held in the year 2011. My lord, after publication of the result of the written examination, certain irregularities were found and the election, thus recruitment process was cancelled. It was directed to be held de novo. The examination for de novo process was scheduled to be held on 26th of August 2012. Prior to that, writ petition was filed before this Honorable High Court and the de novo process was stayed. After upliftment of the interim order staying the de novo process, the examination was held finally in the year 2014 in the month of March. My lord, we participated in the written examination. Thereafter, my lord, the result of the written examination declared in the month of January 2015. We were successful in the written examination and we are called for the interview process. In the interview process was held in the month of February 2015, my lord. Interview process was completed, panel was prepared, but it was not published. So the writ petition was filed before this Honorable High Court from 2017, praying publication of panel and giving appointments to the candidates, my lord. My lord, one such writ petition went up to the Honorable Supreme Court. Honorable Supreme Court remanded back the matter to the High Court and directed that a special bench will be formulated, which shall hear the question of whether the life of the panel has expired or not. Upon direction of the Honorable Supreme Court, a bench was constituted by Honorable the Chief Justice. My Lord Justice Tapobrata Chakraborty was pleased to hear all these matters and passing a landmark judgment, my Lord, on 8th of January 2021, His Lordship directed the panel to be published and appointment should be given to the candidates, my Lord. There is also direction that in case the authority found that there are no vacancies, the vacancies should be created, my Lord. Pursuant to the direction of this Honorable High Court, the panel was published in the month of February 2021. After publication of panel, my Lord, appointments were not given initially since there were no vacancies. By a notification dated 17 September 2021, Government of West Bengal, my Lord, created post to accommodate those candidates who have been featured in the panel, my Lord. So in respect of Malda, my Lord, more than 1,000 posts were created to accommodate those candidates. Total vacancies were 1,320, my Lord. Thereafter, my Lord, appointments were issued and after that, my Lord, they published a 5% additional panel also. My Lord, in the year 2022, some candidates made an application under the Right to Information Act, praying for supply of non-joining seats. Since it was a process of 2009 and appointments were given in the year 2021, a large number of candidates did not join the post. So there are several non-joining posts. RTI application was made, and in the RTI application, it was found that 431 candidates in respect of DPSC Malda, my Lord, are still lying vacant, and appointments were offered, but no one interested to join in the post, my Lord. So against those 431 vacancies, my Lord, writ petition was filed before this Honorable High Court in the year 2022, stating praying appointment in those non-joining vacancies, stating two facts. Since it was a process where Madhyamik was the eligibility criteria, and since after change of rules, it has been uplifted to Uchcha Madhyamik. And since after the Right to Education Act, my Lord, question of training also comes into the effect. So writ petition was filed by some candidates stating praying appointment against those non-joining vacancies. Ultimately, this Honorable Court on 26th of April 2024, upon consent by the state and the District Primary School Council Malda, directed issuance of appointment against all the writ petitioners upon fixing a cut-off date. The cut-off date for filing writ petition was 25th of April 2024. Those candidates who preferred writ petition on or prior 25th of April 2024 were directed to be given appointment, my Lord. Well, after this direction was passed, several other candidates filed writ petition before this Honorable High Court, stating that date should be extended and they should be also accommodated. Such writ petition was dismissed, stating that you filed your writ petition after the cut-off date, so it will not be entertained, my Lord. But thereafter, what happened, my Lord? The District Primary School Council and state, challenging the order giving appointment, preferred appeal before the division bench. Division bench found that it was a consent order. You given consent to the single bench to that effect that you will be accommodate these writ petitioners. So appeal will not be maintainable. So appeal were dismissed and liberty was granted to them to approach the single bench in accordance with law. The District Primary School Council thereafter filed a review petition before the Honorable Single Bench. It was heard on 25th of September 2024. Honorable Single Bench, my Lord, upon hearing the parties, finds that since no written consent was given and whether two findings are there, my lord. Since no written consent was given, and even after giving our consent, they are willing to withdraw such consent. So His Lordship Honorable Justice Mantha was pleased to recall his earlier order giving appointments to the candidates, my lord. So the order was recalled on 25th of September 2024. My lord, those writ petitioners challenged the order before the Honorable Supreme Court, stating that once the consent was given, the DPSC cannot withdraw the consent. Such matter was heard in the year on 20th January 2025. My lord, Honorable Supreme Court was pleased to hold that since consent was given, you cannot withdraw the consent, you have to give appointments. So the order was restored again, order giving appointment to against the non-joining vacancies. So they acted upon the order. They published a panel consisting of 312 candidates against those 431 vacancies. Those candidates have been given appointment. They all joined now. Now, my prayer before your lordship that I am not praying that extension of cutoff date. I am praying that since appointments will be given to 312 candidates after expiry of panel against the non-joining vacancies, there are still 119 vacancies in the district of Malda, in the same recruitment process.
yes.
I am praying before your lordship to accommodate us against those non-joining vacancies. This is my case.
But there was a cutoff date fixed by the
Cutoff date. That is
fixed
why
by the coordinate bench.
absolutely, my lord.
Now those writ petitions which were filed within particular date, they were directed to be given appointments.
My lord.
So how this cutoff date, fixation of cutoff date can be diluted?
Yes, my lord. My lord, cutoff date was fixed upon consent. The consent was given by the state and the DPSC. Certainly, thereafter, since they filed appeal, they will not give consent in our case also. That is why I am praying before your lordship to consider my case separately.
Why, once the cutoff date was fixed, an order was passed by the coordinate bench against which an appeal was preferred. Appellate court said no, since you have given consent, appeal is not maintainable. The order of the coordinate bench fixing cutoff date, directing that in the left out vacancies, non-joining vacancies where the candidates did not join, those vacancies are to be filled up from the other candidates serially. Now, this order against which the review petition was filed as you have submitted. In the review petition, the review petition was allowed. Calling the order passed by the coordinate. Now, against that, SLP was preferred. In the SLP, Honorable Supreme Court has said, no, once you have given consent, that cannot be taken back. So therefore, the order passed by the coordinate bench was restored. First order.
Restored.
Now, in that order, there was a fixation of cutoff date. So how that can be diluted now?
My lord, that order was passed upon consent. My submission before your lordship, my lord, certainly they will not give consent in my case because their stance has been changed, and in identical writ petition, they oppose the writ petition. They will not give consent. That is why I am praying that since some candidates against the non-joining vacancies after expiry of panel has been given
this
appointment.
order was passed fixing the date in 2023 by the coordinate bench.
No, the cutoff date was 25th of April 2024, my lord.
By which order this cutoff date was fixed?
26th of April 2024.
April 2024. Now, subsequently, this fixation of cutoff date was never challenged by anybody.
Well, it was challenged. It was challenged by some other candidates. My lord, I believe that writ petition is still pending. They challenge on the score that they challenge on a different aspect. They challenge that candidates who have been given appointment, those are less meritorious than us. That was the point of challenge, my lord. That writ petition is
No,
still
but
pending.
fixation of cutoff date was not challenged. Now, today, when the order of the coordinate bench was restored by previous order, first order of the coordinate bench dated 26th April 2024 was restored by virtue of the order passed by the Honorable Supreme
Court.
Now, their restoration of order dated 26th April 2024 means cutoff date, fixation of cutoff date was also revived. So now how this cutoff date can be diluted? They will file your affidavits.
My lord. And another issue, my lord.
Only one thing, my lord.
My lord, there is a background, my lord. There are 3 districts Howrah, Malda, and North Chব্বিশ Pargona. The initial the consent order was given in the Howrah case, and that course was followed in North Chব্বিশ Pargona and Malda. Now the same order was passed by the Honorable Single Bench Justice Mantha. Now in our case, we have controverted the consent because we have never given consent. It was a concession in court itself. Accordingly, we have filed the review application, review in the
Allowed and the order
and
was recalled.
recalled.
But that order was challenged before the
Supreme Court and
Supreme Court revived the order dated 26th
April 2024.
2024.
Now,
Consent given that cannot be taken back.
yes, the Honorable Supreme Court had pleased to observe that the manner by which the Honorable Single Bench has recalled that the order that is not appropriate. And because of that, as the Honorable Supreme Court had restored the order, we have no other alternative. We have given appointment. Now, this this petitioner, this cut-off date, extension of cut-off date, there are other writ petition who had come before this honorable court saying that the cut-off date should be extended. That writ petition was dismissed by the Honorable Single Bench. There was an appeal preferred against that particular order. In the appeal, the Honorable Appeal Court had come to the conclusion that no, this cut-off date is inflexible. It cannot be extended and nothing. That order I am citing before your lordship. Kindly consider. There are.
Well, I am not praying for extension of cut-off date. My point
It
is
is an indirectly extension of cut-off date.
There are still vacancies. Well, honorable,
Maybe, but that is confined to the in another roundabout way. You are seeking
Indirectly
cut-off.
extension. And another issue.
Our court has to pass an order extending the cut-off date. Otherwise, court cannot direct.
Honorable Supreme Court has granted
Just
liberty to
in-
the writ petition.
Hello,
that
kindly consider.
anybody who is affected-
There are two orders. This is with regard to Malda. And North Chব্বিশ Pargona was also there.
Has been held very categorically by the Honorable Division Bench on 26 June 2024.
And it is with regard
Give
to
a
the.
copy of the.
Yes, he is aware of
Come
that.
to page 5.
He
Come
is
to-
aware of the order. This is with regard to North Chব্বিশ Pargona. Similar prayer was made.
Come to page 25.
Yes, data now.
Okay, page 5 of the order date 26 June 2024, June 2024.
This is with regard to North
In
Chব্বিশ.
fact, the petitioner intended to avail, read it.
Page 5.
Yes.
Is page 5 after the quoted portion.
Yes, my lord.
In fact,
In fact, the petitioner intended to avail the benefit of the judgment dated 26th April 2024. The moment the court has restricted the benefit at a particular date and the said order attended finality, having passed in presence of the parties, such date is inflexible and the benefit can only be extended to such persons who comes within the ambit thereof and cannot be extended to others solely on the ground that they stand on the same footing that of the others.
what remains?
And
The order-
another issue.
Well, this order was passed much prior to the publication of the panel by them.
Whatever may be, today you are seeking appointment on extension of this cutoff date. That is the net result.
I'm
How
grateful
that
to
can
your
be
lordship.
granted in view of the order passed by the Honorable Division Bench. A similar matter pertaining to same selection process.
Well, may I
And Malot,
kind notice to this order when passed by the coordinate bench in self-said cooperation.
Whether this order was considered.
Yes.
কোথায়? কোথায়?
The
কোনটা?
report dated. They were directed to file a report.
Yes. Maintainability point has been kept open.
No, order of the Honorable Division Bench was not considered.
Yes,
My lord, they placed that was
So
what I
that is,
No, no.
not the,
I'm
it is
placing
not
or in-
considered.
যে কথা বলছি।
that was not because they were
And
directly
nothing has been decided by the coordinator.
Yes, and maintainability point has been kept open. My lord, another issue I just want to point out, this is very important. My lord, this person was neither in the main panel and waiting list. They are unsuccessful candidate. Panel of the particular selection process was expired 2023, long back. Now, my lord,
The panel expired.
my lord, 10th of February 2023. My lord, there
Yes.
now, my lord, after such a long period of time, my lord, it is nobody's pleasure to come to the court and say, yes,
No,
yes.
Even after the panel was expired on 10th February
Yes.
2023, on 26th of April.
Yes, my lord.
2024, order was passed by the coordinate bench,
Coordinate bench,
giving direction to give appointment by fixing a cutoff.
cut-off date, and because my lord, that order was not on merit because it was a consent order. Purportedly, it was a
Now he
consent.
says that he
Revived
has
by
never
the
given
Honorable
consent.
Supreme Court. Now, my lord, as of now, my lord, what happened? This is the situation. They are the unsuccessful candidate.
My lord, persons who have been appointed, they were also unsuccessful candidates, similarly
Yes,
placed.
but it was by virtue of the order of the Honorable Supreme Court, appointment was given. ডিভিশনের যেটা হয়েছে ডিভিশন হয়েছে যা জানি বলো
Issue.
Before passing order.
We are for the district primary school.
Yes,
council.
madam.
Only one thing, my lordship, kindly see the observation made by the Honorable Supreme Court. That is at page 166.
It's not required. It has been decided by the division bench.
Well, observation regarding the pendency of the writ petition.
Petitioners, affidavit of service
Wrong.
filed on behalf of the petition. Affidavit of service filed on behalf of the petitioners is taken on record.
Well,
Next
deficit
paragraph.
court fees as well.
Matter relates to appointment in the post of primary teachers in the district of Malda in connection with selection process which was scheduled to be initiated in 2009. Stop. Series of litigations followed after initiation of selection process and the long legal battle culminated into an order passed by the single bench, passed by a coordinate bench on 26th April 2020. Stop. In the order dated 26th April 2024, it was observed that candidates who were called for the interview in the said recruitment process, in the aforesaid recruitment process, and have filed the writ petitions before this court till 25th April 2024 shall be entitled to appointments against the existing and future vacancies. Stop. It was further observed that even the applications for addition of party, if filed before the cutoff date, before the aforesaid cutoff date, on or before the aforesaid cutoff date, in that event, added candidates shall get the benefit of the order dated 26th April 2024. And shall be treated similarly circumstanced like writ petitioners. In WPA 25712 of 2022.
Yes, madam.
Stop. In the present case, though petitioners participated in the effort, next paragraph. In the present case, though petitioners participated in the aforesaid selection process, but they have filed the writ petition on 28 March 2025, claiming appointment in the vacancies of primary teachers or in the vacancies of primary teacher in Malda, since some of the selected and eligible candidates did not join the posts.
Yes. Non-joining because
Stop. Today, they join the post. Next paragraph. Today, next paragraph. On behalf of District Primary School
Yes.
Council, Malda and state respondents, prayer of the petitioner is opposed on the strength of the order passed by the coordinate bench. Passed by the Honorable Division Bench, dated 24th June 2024, passed on an intercourt appeal being MAT 994 of 2024. Intercourt appeals being MAT 994 of 2024, Rakhi Chakraborty versus State of West Bengal and others, and MAT 996 of 2024, within bracket Shanaz Begum versus State of West Bengal and others. Next paragraph. It is submitted. Issue is no more res integra, since it is decided by the Honorable Honorable Division Bench in order dated 24 June 2024 that relaxation of cut-off date is not possible considering the date of filing of the writ petitions by the respective parties. And today, if present writ petition is allowed, court is required to extend the time for giving appointment, extended time for giving direction to appoint the petitioners. Next paragraph. Having considered the submissions made on behalf of the respective parties, it appears though effort is made by the learned advocate representing the petitioners to make out a case that it is not a mere extension of, or it is not a case of mere relaxation of cut-off date, which was fixed, cut-off date which was fixed by the order of the coordinate bench dated 26th April 2024. But petitioners, being eligible candidates and in view of availability of vacancies due to non-joining of some candidates from the panel, right is accrued in favor of the petitioners in this writ petition to get offer of appointments. Next paragraph. Such contention raised on behalf of the petitioners is found to be not acceptable in view of the issue decided by the Honorable Division Bench in Rakhi Chakraborty Supra. Stop. Today, if court gives direction upon the concerned respondent authorities to give appointment to the petitioners in the posts of primary teachers in the district of Malda, in that event, the cut-off date of 25th April 2024 fixed by the coordinate bench video order dated 26th April 2024 has to be relaxed. Stop. Such scope is no more left open in view of the issue decided in Rakhi Chakraborty Supra. Stop. Relevant part of the order of the Honorable Division Bench in Rakhi Chakraborty Supra is quoted below. এইখানে না এটা সিক করে দেবে, বুঝতে পেরেছো? এটা অ্যাটেন্ড হবে, অ্যাটেন্ড টাইপোগ্রাফিক্যাল মিস্টেক, অ্যাটেন্ড করে না। So, next paragraph. In view of aforesaid discussion, no relief can be granted to the petitioners. Writ petition stands dismissed. Yes, but you have argued well. You are fully prepared with the matter.
Well, I paid the deficit.
My lord,
You have
only,
tried your best.
my lord, only one thing, my lord, in my submission, my lord, I am also, my lord, taking the point of that the petitioner had failed in the recruitment process, my lord. This,
আচ্ছা ওর যে সাবমিশনটা ওখানে আরেকটা in addition there to it is also submitted on behalf of District Primary School Council that petitioners are not the impaneled candidates for
I'm
being appointed in the post of primary teachers. Therefore, no right accrues in their favor.
I'm getting.
Item number 4.
Question for the state led by Mr. Shuddhadev Baduk.
You are the unmarried daughter. Unmarried daughter. When father died, 4th October 2020,
2023.
23. What about mother? Mother predeceased father. What is the date of mother? 2020.
2022.
2022. Where you have stated? Paragraph 4, page 3. And where is the date certificate of father? P3. In July 2022. 4th October 2023. And your legal aid certificate is page 19. Petitioner name is at serial number 5. Now your pension papers are lying where? When you have made application? Page 18. Now, what about your income certificate? Because if your income is 9,000 rupees, you will not get.
Income certificate is 7,
Is 7. Rita, 3,000 rupees. Oh, this is to certify the monthly income. Yes.
Actually, now I
Why the family pension is not being sanctioned in favor of the petitioner? You are for the state.
actually led by Mr. Shuddhadev Baduk. He engaged.
Yes, why the family pension is not being paid to the petitioner? Unmarried daughter, income certificate is furnished, legal year certificate is furnished,
Mail.
Page number 18, let it be considered, madam, within a specific period time. Page number 18.
What he will consider?
Take a decision whether, my lord, we have, my lord, checked out, my lord, his income certificate, or, my lord, so and so, my lord. After that, my lord, we take a decision, my lord.
Very good. Let it be considered because you have made a represent application on 20th December 2024, not long back. Affidavit of service filed on behalf of the petitioner is taken on record. Stop.
Appearance.
Petitioner claiming to be unmarried daughter of a deceased primary teacher has laid claim for sanction of family pension since father of the petitioner, who was a primary teacher, died on 4th October 2023 and mother predeceased father on 13 July 2022. Stop. It is also submitted that legal heir certificate dated 23rd December 2024 issued by the appropriate authority supports case of the petitioner, and income certificate has also been issued by the concerned block development officer, Tamluk, or concerned block development officer Tamluk, Purbo Medinipur, dated 21st March 2025, wherein it has been certified that monthly income of the petitioner is rupees 3,000 per month. Rupees 3,000. Stop. Next, stop. It is further submitted that an application has been made for sanction of family pension in favor of the petitioner on 20 December 2024, addressed to the District Inspector of Schools AC, Purbo Medinipur, being respondent number 4, and same has not yet been decided. Next paragraph, state respondents are represented by learned advocate, and it is submitted since an application for sanction of family pension has been made by the petitioner. The same may be decided in accordance with law. Next paragraph, having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing the district inspector of school, directing the respondent number 4 to decide the transfer, to decide the application of the petitioner claiming family pension, which is at page 18 of the writ petition, by 4 weeks from the date of communication of this order, after granting opportunity of hearing to the petitioner, to the petitioner or her representative. Stop. At the time of taking such decision, petitioner shall be at leave to rely upon all the relevant documents based on which she has laid claim for sanction of family pension. Stop. The decision to be taken by the respondent number 3 or respondent number 4 shall be communicated to the petitioner by 7 days thereafter. Next paragraph. If it is, if family pension of the petitioner is allowed, in that event, respondent number 4 and respondent number 3 are directed to take necessary steps for early release of family pension in favor of the petitioner on compliance of necessary formalities. Stop. Urgent Xerox certificate copy. Next.
Item number 5.
Take it, please. Yes.
Scale of plea was they are having B.Ed qualification. And government policy was that B.Ed months which courses are entitled to be taken. Subsequently, matter has come before the Honorable High Court and ultimate decision that is held there that they are without which means they are entitled to get a category scale of payment. Now, on 4th of April 2025, your lordship also passed a similar direction.
My lord, only difficulty more than one petitioners.
He will
Deficit.
no, but the problem is this, in that writ petition also, I am not entertaining more than one petition. If your writ petition can be entertained in respect of first petitioner, and I'll grant over leave to the petitioner to file a fresh writ on the self-same cause of action. That I've seen. But see that they are working in different schools. Their dates of appointments are different. How it is possible for the commissioner to take decision when court is finding it difficult to decide the issue in connection with separate matters? Then why the secondary teachers will not get the same benefit? All teachers will come and pray for sanction of postgraduate scale of pay. Issue. Affidavit of service filed on behalf of the petitioners is taken on record. At the next paragraph, at the threshold, question is raised how writ petition at the instance of more than one petitioner, petitioners is maintainable, since petitioners have claimed A category scale of pay, being teachers working in different primary schools, and their dates of appointments are different. That is the বড় তো? ঠিক আছে. Dates of appointments are different. Stop. It is not a case of common cause of action based on which petitioners can join together in a single writ petition, claiming their claims, claiming benefits of A category scale of pay. Next paragraph. At this stage, learned advocate representing the petitioners submits that let this writ petition be entertained in connection with first petitioner. Who has affirmed affidavit?
The
First
petitioner
petitioner has affirmed affidavit.
Yes, madam.
Saddam Hussein. Who has কি বললাম at this first petitioner or in connection with petitioner number 1, hereinafter referred to as petitioner, quote unquote, and rest of the petitioners may be granted leave to approach this court with separate writ petitions on same cause of action. Next paragraph. Considering the submission made on behalf of the petitioners, present writ petition is entertained in connection with petitioner number 1, or in connection with the petitioner, in connection with petitioner number 1, and rest of the rest of the petitioners are granted leave to file writ petitions separately, claiming to file writ petitions separately on self-same cause of action. তারপরে এই অর্ডারটা সেট আউট করে দেবে। অ্যাফিডেভিট সার্ভিসটা উপরে হয়ে গেছে, এইখান থেকে এটা সেট আউট করে দেবে। পিটিশনারটা তো করাই আছে। ইয়েস, ডিসপোজড অফ।
Item number 6.
In this matter, I am from the council matter, district primary school council.
Same order.
One petitioner, sorry.
Let same order be passed. A single petitioner, Shubhendu, same order করে দেবে। Disposed of.
Diplomas.
উপরে affidavit service filed on behalf of the petitioner is taken on record. Next.
Item number 7.
I am from the district primary school council, led by Mr. Boisho.
Single petition. Happy for this.
That A category scale of.
Single petition.
Yes, respondents state
Right,
and
sir.
you don't have any objection because I have passed similar order in other matters. Yes, disposed of.
Item number 8.
Four petitioner.
Same order.
As item number 5.
ওটাকে 4 করে দেবে শুধু, একই সেম অর্ডার ডিসপোজড অফ।
Item number 9.
DPSC मुझे दो। Two petition under.
Two petitioner, one maybe.
টু পিটিশনার্স, বুঝলে, সেম অর্ডার করে দেবে। টু ইন রেসপেক্ট অফ টু পিটিশনার্স একটু চেঞ্জ হবে অর্ডারটা, ওটাকে একটুখানি করে দিতে পারলে তুমি করে দাও, নাহলে আমি কারেকশন করে দেবো। রেস্ট অফ দ্য পিটিশনার্সটা হবে না, যেটা আমি ইউজ করেছি, বুঝতে পেরেছো? Another petitioner may be granted is granted leave to file afresh on the self same cause of action. এইভাবে করে দেবে।
Item number 10.
I am for the board lordship.
May I pray for adjournment?
Why?
Because I'm
This
not.
can be disposed of lordship. This is the issuance of trade certificate lordship. Coordinate bench I already disposed of this matter. May I hand over the order? This can be disposed of lordship. A single page order.
Well, not today. Come back tomorrow. Come back ready. Next.
আগে বললে তো আমি অর্ডার দিন না। অর্ডার দিন না।
Not today. As একটা order করে দাও, as prayed for on behalf of the petitioner, hearing of this matter stands adjourned. List the matter under the same heading on next Tuesday. It's a primary day.
Lordship, I am led by Mr. Bishwas. Lordship.
Yes, next Tuesday.
Next Tuesday probably.
Next Tuesday is holiday lordship.
Thursday is also primary day.
No,
Only.
Thursday is not only once in a week. There are other secondary, Madrasa, higher secondary, all are there. Well, not today, not today. Are you ready with the matter?
I'm not ready with the matter. But
Lordship, can you
since my
pass
learned
it,
friend
pass
has-
it over because this
Well,
is
not
disposed
today,
matter.
not today, not today, not today, not today, not today.
এটা তোমার।
Yes, next matter.
Item number 11.
My lord, I am appearing on behalf of the petitioner.
Lots of one matter is was going on just now. Order is being delivered. Also, may I pray for 5 minutes passover? Also,
May I start in the
Let-
meantime, my lord?
Let us go. Last occasion also.
My lord, guardian and
Very sorry,
teachers
sorry,
filed my lord application for addition of party.
yeah, to me, additional party, guardians and teachers.
Honorable Chobi. Vice Chancellor. Vice Chancellor. Hello? Okay. Oh. একটু করে। হ্যাঁ। আচ্ছা, বলতে পারবো। The files are both world of issues.
Yes, please, please.
My lord, in this matter, my lord, petitioner was appointed.
So before that, we have got two applications for addition of party.
No way connected.
I have filed the
I
application.
have challenged
They
my
are
transfer application, my lord.
no way
Let me consider the transfer issue. Yes.
My lord, this petitioner was appointed as assistant teacher in the Madrasa on my lord 6th of August 2001. And subsequently, my lord, his service was approved, my lord. And my lord, ultimately, my lord, he is rendering his service since 2001.
Appointed on and from
My lord, 10th of August 2001.
where from you are getting this?
Petitioner page 21. Allowed to join the duty.
Yes, sir. Holding the key from top.
So you joined as headmaster on 10th August 2000
Assistant teacher.
to the headmaster. Yes, yes, yes.
And next page is my approval of appointment by the district inspector of school.
As assistant teacher,
As assistant.
10th of August 2001. Yes, yes.
Subsequently, my lord, an advertisement was prescribed by the managing committee of the Madrasa for appointment of assistant headmaster. And I have duly participated in the said selection process. And I was appointed as in the post of assistant headmaster by issuing the Madrasa authority by issuing my lord 11th of February 2022. My lord issued the appointment letter to the post of assistant headmaster, page 30.
Yes.
And ultimately they are
11th February 2022. That has been approved.
approved.
Where is the
Prior
approval
to
memo?
that, the erstwhile PIC was not handing over the charge. So therefore, my lord, I have filed one writ petition, and in the writ petition, one in contempt application, kindly turns to page 48 1. The conduct of the Madrasa authority. 1 lakh rupees cost was imposed upon the PIC.
48.
48. The contempt.
Just a minute. Yes, not. Yes.
Now, my lord, kindly turns to page 37. This is the approval of appointment by the district inspector of school to the post of assistant headmaster in favor of the petitioner.
Page 37.
Page 37. Remarks. The approval of appointment to the post of AHM is hereby accorded provisionally subject to the final outcome of the repetition being number 2208 of 2022.
Yes.
My lord, WPA 2208 of 2022 has already been disposed. So, my lord, I am rendering my approval of appointment.
Why this writ petition was filed for taking over charge?
No, my lord. They have challenged the entire process of, my lord, manner of selection of assistant.
Who has challenged?
My lord, one Jahangir Alam and another. My lord, some teachers. My lord. But ultimately, in appeal also, they have lost their case. Now, ultimately, since, my lord, from the date of my joining, my lord, I am rendering my service as assistant headmaster in the same master.
Yes.
Ultimately, my lord, on kindly turns to page 51.
Yes.
51. This is the recommendation of for transfer issued by the Madrasa Service Commission. The recommendation of assistant teacher for transfer on the basis of the recommendation of the Directorate of Madrasa Education, West Bengal, in terms of Rule 33D of the West Bengal Madrasa Service Commission recruitment, selection and recommendation for the persons for the appointment of transfer to the post of teaching and non-teaching staff rules 2023. Now, on the basis of the recommendation of the OSD and EO, Directorate of Madrasa Education, West Bengal, in the interest of the public service and for the welfare of the students, Baijit Hossain, the assistant teacher, Bengali, honors of PG, Dhulian High Madrasa, is hereby recommended for transfer from Dhulian High Madrasa to Malad Rahatpur High Madrasa, So, my lord, I being appointed now, presently, my lord, rendering my service as the assistant headmaster of the present school, that is the Dhulian High Madrasa. My lord, the Madrasa Service Commission transferred me administratively to a madrasa in the post of assistant teacher, demoting me from the post of assistant headmaster to the assistant teacher. That is not permissible. For that, my lord, I will lose, my lord, one extra incremental benefit and as well as the rupees 500, which was granted by the government, my lord, for rendering my services as the assistant headmaster. And my lord, kindly turns to the next page. On 19th of March, Malad, this recommendation was issued by the Madrasa Service Commission.
Where is this recommendation by the OSD?
Malad, that is not. Malad, in this matter,
I have come with this recommendation.
Malad, in this matter, the role of the Madrasa Service Commission is mere like post office. Malad, they are acting on the direction made by the Director of Madrasa Education.
OSD and EO.
Madrasa, yes, Malad. Madrasa Service Commission, he is Malad.
Director of Madrasa Education, right. West Bengal in the interest of...
Yes, Malad. Now, my lord, kindly.
Yes, yes. Where is the... Show me.
This is not under check.
Director
It's the wrong order.
But then another.
Please wait. Take your seat, please. It's a wrong order because this petitioner was considered to be an assistant teacher of the parent school, parent madrasa.
So far the definition of teacher is concerned in terms
No, no,
of the
how
act.
an assistant headmaster can be transferred to the post of assistant teacher? Show me any provision.
So Lordship, what is the
Can it be done?
Lordship, may I? In terms of
And
this,
he has been described as an assistant teacher.
yes, because in terms of these rules, Lordship, there is no provision of assistant headmaster. Lordship, the assistant headmaster, Lordship, neither in the rules nor not in the act. Lordship, what is the definition?
So
of
therefore, the
teacher?
assistant headmaster can be demoted to the post of assistant teacher. Under what provision?
Lordship, this assistant headmaster has no
Unless and
name-
until you initiate a disciplinary proceedings, punish the petitioner, pass an order. This is a punitive transfer order.
Now, Lordship, the power of transfer is given.
This definition pales into insignificance in view of the order passed by the OSD.
Now, Lordship, what is the power?
Very well, you file your affidavit. In the meantime, I'll stay the order.
Kindly come to
Yes,
the
yes.
power. Kindly come to Rule 33D. Kindly come to Rule 33D.
How you are interested? It is not on the basis of your complaint any action has been taken. No, in the order, in the order passed, in the order passed, in the order passed by the OSD and ex officio director of Madrasa Education, it is stated that there is a necessity of a Bengali teacher in Rahatpur High Madrasa.
Yes.
Not on the basis of the fact that he is not an appropriate assistant headmaster, or he is not an eligible assistant headmaster, or he is not an approved headmaster, assistant headmaster, he is being transferred. So the very basis of this order is wrong. Because what is the reason given by the OSD and ex officio director of Madrasa Education? That now in terms of Rule 33D of the Madrasa Service Commission, recruitment of selection of so-and-so, rules 2020, Baijid Hossain, assistant teacher, subject so-and-so, presently working in Dhulian, is assistant teacher. And what is the reason given? That as per vacancy report received from so-and-so Rahatpur High Madrasa, it appears that post of assistant teacher subject Bengali is lying vacant since long. That is the reason.
What is the?
I could understand if on the basis of your, if on the basis of your complaint, this would have been done. It is not. Reason is nowhere it is stated by anybody. Reason is there is a vacancy of assistant teacher in Rahatpur High Madrasa. That's why this has been done.
We are the most.
Yes, Mr. Mukherjee.
Yes.
Kindly have a look into page 37. One thing, my lord. Well, they are, page 37, they are written, the approval.
Yes, show me that any provision that an assistant headmaster of a madrasa can be transferred to the post of assistant teacher of a madrasa.
He is not at all assistant headmaster, my lord. Kindly come to page 37.
I will hear you later. Please take your seat. Don't interrupt this court in this fashion, since you have taken out an application. Yes.
So far the definition of teacher is concerned in terms of the rules 23. Teacher means includes headmaster, headmistress, superintendent, assistant teacher of different categories. That is postgraduate, graduate, undergraduate, etc. So Lordship,
Where from you are reading?
That is the rules.
Show me the rule.
Lordship, kindly come to the 2023 rules.
May I hand up?
Just a minute, I have the manual. Headmaster's.
Rule actually 23.
Yes. Yes.
So Lordship, this book there will be no.
Which rule you are relying upon?
This is the old book, Lordship. There is no. Kindly consider this gadget note. Because, Lordship, this transfer order has been issued invoking Rule 33D. Transfer on special ground. Kindly come first 33D. Lordship, may I?
Lordship, that judgment, that hearing was continued. Now, delegates. Sorry, I was.
See the commission
একটু shift করে
speak to these Yes, rule 33D.
Yeah. Well, I was not there. May I?
Moot question is this.
Is it
A
punitive?
person has been transferred from the post of as assistant headmaster to the post of assistant teacher.
Correct.
Now, it was not an suo motu decision by the commission. Commission has given effect to the decision of the OSD and ex officio director of Madrasa Education.
Correct.
So therefore, it was not the decision of the commission. It was the decision of the OSD ex officio ex officio
It's a based
director
on
of
his
Madrasa
record.
Education.
Right.
Now, do you have the copy of this order of the dated 19 March 2025 of the OSD?
Yes, I have.
Please come to this order.
I have.
Mr. Dhar.
Director's order.
Please place it before me.
Yes.
Then you
But
can
it
also
starts
understand.
with as per vacancy.
Yes, right. Please place it.
As per vacancy report received from Rahatpur High Madrasa, District Uttar Dinajpur, it appears that the post of assistant teacher subject Bengali category such and such is lying vacant since long. Consequently, the teaching learning process in the subject Bengali is suffering in Rahatpur High Madrasa, Uttar Dinajpur.
So that is the reason.
I'm coming.
Yes.
Yes. Of course, whatever is, I cannot add anything.
Yes.
Now, in terms of Rule 33D of the West Bengal Madrasa Service Commission, recruitment, selection and recommendation of persons for appointment and transfer to the post of teacher, non-teaching staff rules 2023, Bajid Hossain, assistant teacher, subject Bengali category, honors PG, presently working in Dhulian High Madrasa, Murshidabad, is hereby recommended for special transfer from Dhulia High Madrasa to Rahatpur High Madrasa District, Uttar Dinajpur. He shall, kindly mark this question, draw pay as per LPC, last pay certificate, issued by Dhulian High Madrasa, such and such. Right. First paragraph is the reason. Second paragraph is the impugned, not impugned, that's the reason. And the last line is without affecting his pay because there is some increment. Well, as Lordship formulated, possibly two. One, is it punitive? Apparently, answer is yes, because there is a looks like as if it's a
demotion.
It's a kind of demotion.
It's a demotion, even if last pay is kept intact, is not interfered with.
I've understood.
Even that is a demotion.
I'm coming. So this is the first question. And other question is, if that is the reason, does law permit? These are the two things. Now, first, my lord, if I try to answer first. My lord, the post of assistant headmaster, this is not a separate cadre at all. Number one. This is a functioning designations in a particular institutions. For an example, in a particular school, there are 700 students. Now, for 700 students, it may be difficult for an administrative person being a headmaster to run. So he needs an assistance. For the post of assistant headmaster, there is no such recruitment process in a sense. Everyone can participate. It is an intra-institutional arrangement. So that's why, my lord, I am using the word is a functional designation. So the cadre that he belongs to is the assistant teacher, always. Now the question is, by virtue of intra-institution functional designation, which is not a separate cadre, he gets a little bit of, I don't know what it is called, increment, some extra amount of money. Now that part is protected. Now kindly, Lordship, look at the issue from a different point of view. Assume it is a assume. If it is not, of course it's not. Assume it is a transferable job. If it is a transferable job, can he say that because I am the assistant headmaster and my cadre belongs to assistant teacher, I can never be transferred anywhere other than assistant headmaster? Because there are thousands and thousands of the schools, number of students are less. The requirement of assistant headmaster only when the students are more. I believe there is a number approximately 700.
But Mr. Dhar, following a particular procedure, assistant headmaster has been appointed. Is appointed.
Intra institution.
Maybe.
Intra.
But that has to be taken care of by the authorities by framing an appropriate rules. But if it following a procedure and an appointment is made by preparation of panel was approved, then the petitioner was appointed in the post of assistant headmaster. That appointment was approved by the district inspector of schools. Why is there any necessity, so far this court is concerned, to go beyond this the issues or facts, go beyond the fact relating to appointment of assistant headmaster?
That is the pertinent question.
Because today if your rule is silent on with regard to transfer of assistant headmaster, nothing can be done.
But that's I come.
Court by passing a mandamus cannot give a
Correct.
license to the
Agreed.
authorities. Yes, you transfer the assistant headmaster to the
Agreed.
post of
Agreed.
assistant teacher.
Agreed. Now I will demonstrate before your lordships that my rule permits the transfer.
And it is not your decision.
No, it
You
can't
have
be my-
acted as a post office.
No, I have not acted as a post office.
Yes, it appears so.
No,
it is not your decision, Mr. Dhar.
But I have
It is a decision of the WSD.
kindly come to
And
have-
what is the basis of this decision? That there is a teacher working, there is a dearth of teacher of Bengali in Rahatpur High Madrasa.
Madam, may I-
So I will direct the DI to find out that whether any other excess teachers are there in the school in the district who can be transferred to Rahatpur.
May I first answer lordship first query? That I am acting as a post office.
Who is appearing for the state?
Kindly take 33D. No, the law requests that. I can't do it. Kindly come to 33D.
I have seen 33D.
Kindly see if
Yes,
the commission is satisfied. So I can't satisfy suo moto. On recommendation of the director of Madrasa Education. That's what is the requirement. So I can't. So there has to be a recommendation.
No, that the moot issue is recommendation. Your satisfaction cannot be made in the air, Mr.
Yes,
Dhar.
yes.
So what was the reason for recommending such transfer?
So now lordship is on the reasoning that
Yes,
now
because yes, you are absolutely correct. This satisfaction is required to be recorded or is
my
expressed.
satisfaction cannot
But
be exclusive.
your satisfaction depends upon this recommendation of the directorate.
Correct.
So what is the basis of this recommendation?
There is a chair দিন। My lord, that's the
Your satisfaction depends upon recommendation.
exactly my satisfaction. If I can use this, well, this is an interesting case. I would love to argue no matter what happens. My satisfaction does not have exclusivity of satisfaction of myself. In other words, my satisfactions would be only after there is something called a recommendation of somebody else. Now the question comes that there is a recommendation, rightly or wrongly.
So if recommendation goes,
So, if the recommendation, everything goes.
your satisfaction
My
has no basis.
Absolutely.
So therefore, the state has to substantiate the
Correct.
basis of this
I
recommendation.
have been able to possibly come to a very close to about.
There
the
is
persuasion
Mr. Rai, you file a supplementary affidavit placing this in order to bring this order on record. Yes, I'll direct Mr. Mukherjee to supply a copy to you. And in the meantime, there shall be stay of
Well,
operation.
there is
You have no case at this stage.
Well,
Yes. Yes, I'll consider you at the time of hearing.
there is a actually please allow me. I'm not finished. Just
I want to show a document, my lord. Perversity on the part of the director of Madrasa.
But that is not on record.
Yes, my lord, that is on record.
This order is on record.
This order is not on
Then-
record. But my lord, on 19th, my lord, the commission recommended me on administrative ground on 21. My lord, page kindly turns to page 54 once, my lord. 54.
Yes.
That this OSD and your director of Madrasa Education directing the district inspector of school to issue release order. Now, relying the rule 3011. Now, in terms of rules, paragraph second paragraph. Now, in terms of rule 3011 of the West Bengal Madrasa Service Commission recruitment, selection and recommendation for the person appointment such and such, I hereby directed to release by execution. Now, I will kindly turns to rule 3011(1). When 3011 is applicable. We internal test 30. In case of failure on the part of the Madrasa authority or the head of the Madrasa to release, the applicant shall apply to the concerned district inspector of school or authorized officer who shall take necessary steps for immediate release along with necessary certificates such and such. Well, this rule is applicable on when applicant applies before the district inspector of schools. Well, I am not getting the release order. And here, what prompted the director of Madrasa Education to directly direct the district inspector of school to issue release order?
Well, I've
See the situation.
And the school, by relying who is the transfer order was
It
passed.
appears as a special case so far the state is
it
concerned.
I have taken note of. Kindly, it's a very recent judgment of 2000. Kindly, sis. Well, there is a very fundamental point here. All I'm trying to say, if it is not a transferable, if he is able to convince your lordships that the moment I become the assistant headmaster, then nobody can touch me, I have to be there, then of course
No, that is not the that should not be the notion.
now if it is a
Notion should be if your rule permits, you will be transferred.
yes,
But by giving credence to the definition of teacher, the ambit of your transfer rules cannot be widened.
yes, I agree with that. I agree with that. Of course, but that has to be my
So,
parameter.
the appropriate rule has you frame an appropriate rule
Well, I have
for
a rule.
transfer of the assistant headmaster.
I have a rule. There is no assistant headmaster.
Nothing. Your rule is completely silent with regard to transfer of assistant headmaster. What can be done?
May I say this? There is kindly have a look. May I just place it and then
Not at all applicable in my case, my lord.
No.
Because I was appointed in 2001.
But this
This
is
rule has came into effect from 2008.
division bench have answered these questions.
May I-
Nobody
I
can
have-
say that.
No, first whatever irrespective of the submissions made by both of you, first my query is that what was the reason for such decision by the West?
Madam,
And not only this,
I'm
by
giving-
applying,
I'm
he has rightly pointed out, by applying rule 3011,
Yes.
that is not applicable.
That is
Yes,
post.
means-
But
no. See the malafide intent of the or
Correct.
malafide on the part of the state of.
Well, I accept every point. Now the first point, kindly take this 2024 judgment, which was based on an.
First, I will hear this will come later. First, I will hear the state.
No matter
It's a root of entire thing. Your satisfaction depends upon the recommendation.
No, may I say this?
Now, who is appealing for the state?
Well, state will kindly allow me, Malad, only this
No,
part.
no, not at this stage. Mr.
Malad, this.
Though
Malad,
I will not permit you to widen the scope of
then,
this
but
petition.
Lordship, then what happens? Lordship is going to pass an interim order. All
For a
I'm saying-
limited period.
because
Let it.
that's true, but kindly consider, Malad, give me 5 minutes by clock. 5 minutes by clock. Kindly take my 2024 SCC online. This is paragraph 9. First, there are all transfer cases have been taken into considerations and parameters have been.
Mr. Dhor,
Yes.
these transfers are based on the rules. First, I will consider the rule.
Then kindly,
If your rule applies,
Yes.
is applicable for transfer of an assistant headmaster, nothing remains.
well, I say there
But if
is-
your rule is silent with
there
regard to transfer of an assistant headmaster, nothing can be done.
kindly take the rule.
Yes.
I say my rule
Yes, yes.
covers him. Kindly take the rule. The definition of 2, my lord, XXII, that is 22.
It's a definition of teacher.
Yes, that's an inclusive definition.
Yes, by the with the help of definition
Now,
of
why?
teacher,
Well,
you cannot widen the scope of transfer rule.
But may I say why I can? May I say this? Because to my understanding, there is no separate cadre for the assistant headmaster. Kindly
So
visualize
it
this.
can be looked into from a different angle also,
Yes.
that the transfer of assistant headmaster may be kept outside the purview of the transfer rules.
Well, then it would be, may I say
Why
this?
the court will decide the issue? That is not the issue before this court.
Well,
You are trying to project it as an issue.
Yes.
Where if the teacher, definition of teacher in your transfer rule is silent
Yes.
with regard to, or it is not an exhaustive definition,
Yes.
including the assistant headmaster,
Yes.
then it can be looked from a different angle, that the transfer of assistant headmaster is not the object of the rule makers.
Lordship is considering assistant headmaster as if a separate cadre. It is not a separate cadre.
Is
It is
at the
someone-
end of the day, he's an approved assistant headmaster getting financial benefits.
So
If the petitioner is transferred to some other school
Yes.
in the post of assistant teacher,
Yes.
then it's even if there is no monetary loss,
Yes.
that is a demotion. So far, the headmaster, assistant headmaster is
all
concerned.
I'm trying to say.
He's not a teacher in charge, Mr. Dhar. It's not a case of teacher in charge.
Correct.
The post of teacher in charge, there is no separate post.
Correct.
But in a madrasa
Yes.
or in a school,
Yes.
post of assistant headmaster is an approved post.
My lord, all I'm saying is this, that
Had he been a teacher in charge,
yes,
then I could have accepted your contention, because it is a stopgap arrangement. If assistant headmaster or headmaster is there in the school, question of presence of teacher in charge does not require. But when a teacher, when the petitioner is working in an approved post of assistant headmaster in a school, how he can be transferred from an approved post of assistant headmaster in madrasa to an approved post of assistant teacher in a school in another madrasa?
my lord, my one sentence answer is this.
And what is the reason behind that? Reason is, as it emanates from the order of the
There is a vacancy.
OSD, that
There is a
a
vacancy.
Bengali teacher is required
Yes.
for manning the post of an assistant teacher in Bengali in Rahatpur High Madrasa. Is it a case that there is no other school madrasa in the school where excess Bengali teachers are not there?
The Supreme
So I want to hear the state on this issue.
Assistant headmaster, then lordship may
How from an approved post, unless and until it is a case of, if you now argue on the point that it's a punitive transfer, I am ready.
no,
If
it
it is
is-
case of punitive, if it is not a case of
not a
punitive
punitive.
transfer,
it is not
if it
punitive.
is not a case of punitive transfer,
Yes.
a candidate
Yes.
or the petitioner working in an approved post of assistant headmaster, how he can be transferred to the approved post of teacher in charge, assistant teacher in another madrasa?
Madam, there is a possibility that the way I'm thinking could be completely wrong. It could be. So it's a
Can that be explained on the basis of the in your inexhaustive definition of teacher? Mr. Dhar, please apply your mind on this issue.
I would
Yes.
love to. I would love
Can that be covered up by way of an inexhaustive definition of teacher as attributed in your transfer rules?
But two options are there. One interpretation could be that once someone becomes an assistant headmaster, then there is an vacuum and no existence.
So
of-
therefore, allow me to hear the
Decide-
state on this issue. Yes, because your recommendation in terms of these rules, just a minute.
Provisionally approved. Final that is not approved.
Well, there
Just a minute, just a minute. 30,
37.
yeah, you have relied upon this recommendation and satisfaction. Which rule?
Well, this is rule West Bengal Madrasa.
Yes, it is referred to the transfer order. Just a minute.
33D.
Lordship has copy of the entire rule.
Yes, yes. Your junior has handed me.
Well,
Just a minute.
I am relying on
33D.
33D.
33D. Just a minute. Yes, 33D. Now in
say-
33D, if the commission is satisfied on recommendation of the directorate,
Yes.
first comes the recommendation of the directorate,
Right.
then your satisfaction review. So I want to hear the state. I will not pass a blanket order of injunction for an indefinite period, because this order of the OSD is also required to be brought on record.
True.
It is not part of the record, so I will grant leave and I will direct your
And this
junior
is an
to hand over a
important
copy.
point for once
Yes.
forever. It can be
Hand
decided.
over a copy of this order to to his learned friend representing the petitioner. Just a minute, please don't interrupt. And I will grant him leave to file a supplementary affidavit within a limited period. And in the meantime, I will direct one of the additional government pleader to appear in this matter, along with.
And I also want, my lord, I will be praying before your lordships. So
Yes,
that
you are for the
once-
state. I will direct one of the additional.
either of
government
the
pleaders to appear in
ways,
this matter.
Suman with me.
Yes, who?
Mr. Suman De.
Suman De.
He's on leg.
No, I will direct any
either of the ways, let this for once for all, let this law point be decided.
Yes.
Because, my lord, one view would be if it is transferable, then there is no requirement of disclosing for what.
I want to hear in this on this issue first. There are two aspects.
Yes.
First is if it is a case of recommendation by the state.
Yes.
Now, why this an assistant headmaster of a madrasa
Yes.
in a district
Yes.
is required to be transferred by way of demotion to the post of assistant teacher? Is it a case that in this district there is no other excess teacher in a school in Bengali, in madrasa in Bengali,
Correct.
that requires such order to be passed? First. Second point is this: if taking cue from your submission, that if the post is approved post of assistant headmaster, and if your definition of teacher is inexhaustive, now whether that candidate
Assistant teacher, not
assistant headmaster, assistant, if the
No.
post is approved assistant headmaster, which is being held by the petitioner,
yes, but
in the present
but my
madrasa,
submission is different. My submission is
whether he can be transferred
yes.
from the approved post of assistant headmaster to an approved post of assistant teacher by taking advantage of your inexhaustive definition as attributed in section 2 XXI.
There should be a then third.
Hey, you frame rules, Mr. Thor, and bring with under the umbrella assistant headmaster. Nobody will prevent you.
There would be a third question, that whether the post of assistant headmaster is an independent separate post or not.
When it is an approved post, sanctioned vacancy is there. You know very well
That is
that in a school or in madrasa,
yes.
it's a single approved vacancy, sanctioned vacancy.
Agreed.
So it creates a different cadre.
All I'm saying, for doing some job, he originally remains with the same cadre. That's my submission. That
It is you who argued before the coordinate bench in the case of assistant headmaster that with regard to the eligibility of the assistant headmaster, it's a reported judgment that assistant headmaster,
even tomorrow
teacher in charge is not the helper. Teacher in charge, assistant headmaster is the driver of a bus, and teacher in charge is the helper. Helper cannot be the driver of the bus.
Even today, if my
Yes, I will consider your application an appropriate time. Yes. At the appropriate time, I will consider it. Yes. During court, matter is heard at length in presence of the learned advocates representing the party. Stop. During course of hearing, an order dated 19th March 2025 passed by West and ex officio director of Madrasa Education West Bengal is placed before this court, wherefrom it appears that
my application.
that a recommendation is made by the OSD and EO Director of Madrasa Education West Bengal on 19th March 2025. For his transfer from the post of assistant headmaster of Bhulian High Madrasa within bracket HS Murshidabad to Rahatpur High Madrasa within bracket HS Uttar Dinajpur. Stop. Stop. The reason which appears to have been assigned in the order dated 19 March 2025 is a requirement of assistant teacher in Bengali in Rahatpur High Madrasa within bracket HS close bracket Uttar Dinajpur. Next paragraph. It is argued on behalf of the petitioner that the transfer order argued on behalf of the petitioner that this recommendation for transfer dated 19th March 2025 and further recommendation for transfer dated also dated 19 March 2025 is punitive or are punitive orders, and the further recommendation for transfer dated 19 March 2025 issued by the Secretary, West Bengal Madrasa Service Commission are punitive orders, since by transferring the petitioner based on recommendation as contained in order dated 19 March 2025, petitioner has been demoted from the post of assistant headmaster to the post of assistant teacher. Next paragraph. In terms of Rule 33 within bracket D of the West Bengal Madrasa Service Commission recruitment within bracket selection and recommendation of persons for appointment and transfer to the post of teacher and non-teaching staff close bracket rules 2023. First, recommendation is required to be issued by the Directorate of Madrasa Education, and based on such recommendation, West Bengal Madrasa Service Commission is required to record satisfaction for transfer of a teacher of madrasa
It's not teacher,
for
it's
public.
staff. Can you see D, any staff? The word is staff here.
আচ্ছা, টিচারটা স্টাফ করে দাও, or teaching and non-teaching staff করো। কি সেন্টেন্সটা বলছিলাম বলো? শেষটা বলো। For transfer in consideration of public interest and or if for transfer in consideration of public interest or for welfare of the students of any madrasa. Stop. Therefore, in terms of Rule 33 within bracket D, first recommendation is required to be issued by the Directorate of Madrasa Education, and the copy of such recommendation dated 19 March 2025 is placed before this court today, and same is taken on record. Now, is placed before this court today. Stop. Next paragraph. Leave is granted to the learned advocate representing the petitioner to file supplementary affidavit in order to bring on record the recommendation dated 19 March 2025 issued by the West D and EO Director of Madrasa Education, West Bengal. So let such supplementary affidavit be filed by 7 days from date with copies upon the learned advocates representing the parties. Next paragraph. Since the decision to transfer the petitioner from the post of assistant teacher to the post of from the post of assistant headmaster to the post of assistant teacher is taken based on such recommendation memo dated 19 March 2025, court desires to hear Mr. Bishopbrata Bosu Mallik, learned additional government pleader. who will appear in this matter. Stop. Let engagement of Mr. Bosu Mollik be regularized by the learned government pleader. By learned government pleader. Next paragraph.
My lord, I'm already,
List the matter under the.
I'm on the state, my lord. He will be leading me.
Yes, he will lead you. List the matter under the same heading. List the matter under the same heading on. 7 दिन बोलना तो. On 22nd April 2025 for further consideration. Next paragraph. Meanwhile, the recommendation. Meanwhile, 50. Transfer order dated 19 March 2025 issued by the Secretary West Bengal Madrasa Service Commission shall not be given effect to till 30th April 2025. Next paragraph. You are for the teachers.
I am for the teachers and the guardians. Page 36
Acha,
only kind of
an application
order
and
is not at all assistant. Page 36.
an application.
Page 36 it is made it clear that respondent shall not claim any special equity on the basis thereof. Page 36.
Whether your application is running in the list,
and
in
one
this list.
petition is still pending.
In application being can one, why two applications?
One guardian and another my lord teacher.
Two applications,
Appointment by
being can one of 2025 and can 2 of 2025 are taken out by some guardians and teachers of.
He is not at all a assistant headmaster permanently. In
Of
the approval order, kindly have a look into the approval order, page 37. Page 37, it is specifically stated, subject to the result of WPA number.
Julian High Madrasa within
That
bracket
petition
HS.
is still pending before this honorable
Murshidabad.
court.
কি বললাম
Kindly add this writ petition along with this writ petition.
Can one of 25 and then for 25 are
and those two applications are to be heard on the next date. Stop. Let both the applications appear along with this writ petition.
Instead of 22nd, can it be 24th? 22nd, my lord, large number of all the group D madrasa matters have been fixed.
Let it be there.
At
If you are not there, I will accommodate you. Because 22nd is the date. Oh, it is not a primary matter. Just a minute. Yes.
Because that matter will continue
yes,
probably whole day. That's it.
Very well on 24th. If I set aside the transfer order, your application is need not be your transfer application. Please hear this code. If ultimately if I dismiss the writ petition, so your purpose is served. If I allow this writ petition upholding the points taken on behalf of the petitioner, thereby setting aside the order passed by the School Service Commission and the state, in that event I will hear you.
My lord, one thing is not at all a assistant headmaster till today, my lord.
Yes.
Yes, 36 on 2 page, my lord. Let it thereafter kindly get fully.
Item number 12.
For the petitioner.
Your Lordship, I am for the state. I am led by Mr. Jayanto Samanto.
Led by
Mr. Jayanto Samanto.
There's self medical reason,
just
transfer application.
এই শোনো তো, মানে একটা দুটো লাইন অ্যাড করে দেবে যে কি মনে by 10th April 2025. Hello. Commission?
Outside. They are present last occasion. Maybe outside they are
But last occasion also no one appeared for the commission.
served upon the commission.
That's why court directed serve upon the commission
Yes,
and the
yes,
and the school authority.
Yes.
When you have served upon the commission and the school authority.
That's served, my lord.
Neither school nor commission.
It is pending at the end of the commission, medical ground.
Where is the commission? Who is appearing for the commission? Are you aware of?
Mr. Roy or Mr. Bandyopadhyay?
Where are they?
I don't know, I have served. It's pending medical ground, it is page 30. It's pending at the end of the commission. কে আছে এই সুনীতকে জানো তো? সুনীত দেখো সুনীত আছে কি?
Issue. Affidavit of service filed on behalf of the petitioner in terms of the order dated 17 March 2025 is taken on record. Stop. In spite of service of notice upon the West Bengal Central School Service Commission and the authority of Nayan Chandra Vidyapith within bracket HS close bracket Howrah. Those respondents are not represented today. Next paragraph. Client advocate for the petitioner is directed to serve notice upon Mr. Kanak Kiran Bandyopadhyay, learned advocate, who usually represents West Bengal Central School Service Commission. Enclosing copy of this order by 10th April 2025. Stop. List the matter under the same heading on 16th April 2025.
Instead of 16th and 17th.
Why?
No,
I have fixed several other matters.
Not my matter, my lord. No, I have
No,
some
no.
difficulty. I have some pre-planned, my lord.
No,
Kindly,
pre-planning.
This
Will
is
be
not
there.
my fault. This is not my
Let
fault.
me see. No.
No, not
Others
on
I am
16th.
also fixing.
Not on 16th. I have some
No,
other,
no.
my lord, engagement, my lord. Kindly, my lord. I'll be in difficulty. Great difficulty, my lord.
Sorry,
Not on
Mr. Lyri. No,
any day.
no,
After
no.
16, 17, my lord, any day. That's my fault that they are not appearing. I have served upon them. Not any day. Kindly. I have
So the members are not coming to on 16 and
They
17.
might come, but I have
You will not come. Why?
I have some difficulty.
Why you will not come? Others will come.
No.
Judges will come.
No, absolutely.
Members of the bar will come. Why will not come?
Not that important.
You are the regular practitioner of this court.
Even if I don't come, things will be done.
No.
Kindly, not on 16th. Not on.
Then let it be on 16. Let me see.
No, then it will go to monthly list of June.
No.
Yeah, June.
No.
Kindly.
16, 17, I will not do this.
Very well.
Let it be on 16. Let me see.
Very well. The affidavit of service.
Ultimately, if you decide to come, then we can hear
no,
this
no,
matter.
no,
Courts can hear this.
No, my lord. It is my.
Yes. Next one.
Item number 13.
Yes, any decision by the...
Yes, my lord.
Where is the decision?
May I file a report, my lord? It's a yes, my lord.
Has been?
Order has been passed
My lord, kindly come to
3rd of April 2025.
third last page.
Third last page.
Yes, my lord. 20 initially representation made by the petitioner long back, but I came to know that
High scale of...
no. In view of the government order, I tried, my lord.
Honestly?
Yes, my lord.
This has been settled.
There was no such...
Now it's not, my lord. There is a government order.
Then you have to challenge it, Mr.
Yes, my lord. They have to challenge, my lord.
They have taken this.
28
yes.
March 2025.
Since the hearing was proceeded, my lord,
17 March, I heard this. You are
Yes,
absolutely
yes.
correct.
My lord, I have made a prayer.
My
Setting
lord
aside
was
the decision.
My lord was
This has
pleased
been-
to
this is
direct
challenge.
me to take this matter to the DI, my lord.
I will dispose of your
Yes,
petition, continue.
Quick call. Because of this writ petition, my lord,
Yes, this is why this matter was kept for...
My lord, kindly say the reason. Yes, my lord, reason. Kindly say the reason. My lord, I don't think cost can fulfill their relief, my lord. Kindly see what is written. in the-
Cogent reasons.
Yes, my lord.
What are those reasons? Tell me.
Previous DI, my lord, they transferred and entire file has been, my lord.
Can it
not,
be a reason?
My lord, in my lord, state government department, my lord, this is a
Whether
common
any
thing, my
administrative
lord.
authority can
But
say
my lord, in
that I
view
have
of your
joined the
lordship
post
order,
recently, that's why there's a delay and this is a cogent
then my
ground.
lord, kindly see. Kindly see, my lord.
You have to take the responsibility of your predecessor.
I asked, my lord, the petitioner to appear on 19 March and immediately order has been passed.
That is after filing of the writ petition and order passed by this court.
My lord, the school.
See the delay.
Kindly see the government order, my lord.
Issue.
He should aware of the government order.
Pursuant to the order dated 17 March 2025, It is submitted,
So
instruction is taken on behalf, instruction is taken by the learned advocate representing the petitioner. Learned advocate representing the state respondents, and it is and it is submitted that prayer of the petitioner for sanction of postgraduate scale of pay has been disposed of. VD order dated 28 March 2025, passed by the District Inspector of Schools AC Purulia. District Inspector of Schools AC Purulia. Stop. Next paragraph, a report dated 3rd April 2025 is placed before this court, prepared by the District Inspector of Schools AC Purulia, enclosing decision of the District Inspector of Schools dated 28 March 2025, and same is taken on record. Next paragraph. It appears on perusal of the order dated 28 March 2025, passed by the District Inspector of Schools AC Purulia, that prayer of the petitioner for sanction in postgraduate scale of pay has not been allowed. Stop. Since in this writ petition, has not been allowed. Stop. The present writ petition stands disposed of, thereby granting leave to the petitioner to take steps in accordance with law against the order dated 28 March 2025. Stop. Urgent Director. Very unfortunate for filing, by filing a writ petition, merely an order is to be obtained from the. Yes, next matter.
Item number 14.
You inform Mr. Bosumolli.
Yes, I.
I have added one line, inform the learned advocates representing other parties that the learned advocate for the petitioner is directed to communicate this order along with copy of the writ petition upon Mr. Bosumolli.
We shall sit, man.
Yes. Yes, yes, yes.
Participating in the Dismissal
16.
and thereafter, my lord,
Upper primary. Yes, so.
and thereafter, my lord, this interview has been called on, my lord, and my lord, in the merit,
Who is appearing for the commission? West Bengal Central School Service Commission. Who is appearing? Have you served notice?
Dr.
But have you served notice? Show me the service upon the commission. Thou to me.
Library service. The upper primary.
Delivered. The issue cannot be decided in absence of the commission because they conducted the selection process. You serve notice upon Dr. Patro and Campbell. Issue. Matter relates to the selection process, that is IE, that is West Bengal, the first state level selection test 2016 within bracket upper primary. And petitioner has participated in the set selection. You have participated in the set selection process. Stop. Set selection process. Stop. Today respondents are today state respondents are represented, but West Bengal Central School Service Commission, in spite of service of notice, is not represented. Opore affidavit service ta kore diyechilo. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon Dr. Sutanu Patro, learned advocate, who usually represents West Bengal Central School Service Commission, by April 10th, 2025. Stop. list the matter under the heading motion, list the matter under the same heading on 16th April 2025.
New motion.
Next,
Item number 15. আমাদের কথা বলছি না
first wife got family pension. First wife died. Now second wife is claiming family pension. Since marriage was solemnized with consent of the first wife. That's why time is being taken. But in that matter, I am not going to post it in the monthly list. Yes, yes, not today, tomorrow. What has happened to him? Illness. Very good. Not this week. Not this week, কোনো order করবেন।
Item number 16.
For the petitioner and for the state respondent.
Maybe impression is a primary matter.
Maybe for that impression, commission is not appearing. Since primary matter in lordship,
Herbal order.
please day, perhaps that they have left.
But there is a rider.
Yes,
I have clarified it.
yes,
Ready?
maybe for that reason. And for that, these matters.
In the event matters under the heading motion from daily cost list are exhausted. No, just if the if time permits. If the yes, note 2, if matters under the heading new motion 1 primary are exhausted, matters under the heading new motion shall be taken up from up to 1:15, and matters under the heading motion shall be taken up from 2 p.m. to 3 p.m.
Yes. But
There is no
at the moment,
ambiguity.
Your lordship perhaps said that today's primary is possible for that reason. Possible
There
for
are
that reason.
how many
Otherwise,
primary matters are there?
Yes, few
Only
matters only.
only first serial number 2 to serial number 10.
Yes.
9 matters.
Well, then let it be not today, then tomorrow let it be done tomorrow. Because coming is
Well, good.
well,
You
therefore
are
that
appearing, state is appearing. Why the commission will think so?
privileged litigant.
Right. Correctly said.
Let it be not today. That's tomorrow. Come now. He's in 8. I'm told he's in court number 8. Division. Very good.
Not today.
Tomorrow morning.
Not on 16.
Not on 16th and 17th.
You will be punished. Though there is no fault or fault in your part.
No,
Yes.
no fault.
Next.
Item number 17.
I am appearing for the state manager with Pratibha Ghatak.
But this is also same pending at the commission.
Commission transfer.
Commission pending at
Commission, who is appearing for the commission first time?
first time. I asked, what's it? Not today, I'll make it not today. Lordship.
You have served notice when find it out.
Yes, yes. They received on 26th March. I can get it. You also. And Mr. Dash is also in the panel. He's also in the panel.
But are you appearing in this matter?
Not appearing.
Vice Chair.
Issue.
Okay, let it be not today.
No, all matters will be posted tomorrow. That will, there is a difficulty.
Short matter, very short matter. Pending at the SSC. No, minor, kindly. No, not.
No, I'm not fixing on 60. Affidavit of service filed on behalf of the petitioner is taken on record. So, in spite of service of notice, West Bengal Central School Service Commission is not represented. Next paragraph. However, however, state respondents are represented by learned advocates. Next paragraph. Since matter relates to transfer, court desires to hear West Bengal Central School Service Commission. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon Ms. Supriya Dubey, learned advocate, who usually represents West Bengal Central School Service Commission. By
দুটো
10th April 2025.
10th April.
Stop. List the matter under the same heading on 28 April 2025.
Can you deal with them strictly? For this?
Yes, right. কেন 28 এর প্রবলেম আছে প্রচুর ম্যাটার নাকি দেখে নাও
28.
Item number 18.
20 Sunday. Yes, next.
For item number 18, I'm for the petitioner.
Yes.
My senior is in code number 14, so paying for spot password.
Who is in code number 14?
Shortcut. Get to code number 14.
And you are for the state. What is the prayer?
Prayer is, my lord, condonation of shortfall of service for pension, nearly 4 years.
At the time of call, accommodation is paid for on behalf of the petitioner. However, state respondents are represented by learned advocate. Next paragraph. List the matter under the heading motion in the monthly combined list of May 2025. Next.
Item number 19.
I'm for secondary body.
Statement.
Yes.
Here, the school authority is approaching this honorable court, my lord.
Yes. For what?
For filling up the vacancies. There are huge number of students, but the teaching strength is too low. There are existing vacancies. We say, took several steps. For authentication of vacancy, we made several requests to the competent authority. Since they are not authenticating, we cannot send the requisition to the full service commission for filling up the posts.
Has to be reported to the DI.
Authentication করার প্রশ্নই নেই।
So why you have prayed for authentication of 100-point roster?
Because if the roster point is not authenticated, we cannot send the requisition. I do
And
not
that
know
is-
which
that-
post
that
is
is not
reserved and
correct.
which post is not
No,
reserved.
no.
is not-
Requisition
Let
has to be
us-
sent to the DI.
My lord, this is a sponsored school where if there is vacancies arise, the vacancy will be reported to the DI.
DI.
Now, my lord, the DI will for whatever vacancy are there, DI will if forward to the commission, and accordingly commission will recommend to the board and board will issue appointment letter. So, my lord, here authentication done, doing authentication of the roster point and sending it to the school does not arise. Because my lord, previously, my lord, DI used to authenticate the post roster was maintained by the DI of each and every school separately. Now, my lord, after the 2018 came into force, board has become the authority, my lord. Now, a central
To authenticate.
yes,
100-point.
a central roster, 100-point roster.
So the job of the school is to only to forward the vacancy.
Vacancy to the DI.
And DI will forward it to the board.
To the board, and board upon the vacancies with the board will forward it to those vacancies to the concerned commission, and commission will recommend those particular names because names are with the commission.
Authentication of 100-point roster is to be made by whom?
Authentication is to be made by the BCW. My lord, board maintains, prepares the roster. The roster is sent to the BCW. BCW authenticates. It is an ongoing process. It never ends because it is ongoing process. So, my lord, as per my lord, after 2016, SLST 6, there is no fresh recruitment. So, my lord, now this question doesn't arise at all.
No, but upper primary recruitment is taking place.
Upper primary is going on.
SLST 2016
Yes.
upper primary.
So, it is going on. It is a continuing process.
Then transfers, avenues.
No, transfer is a separate format.
Yes, by
The-
way, no, but since
two things. Only
since SLST 2016, 9, 10, 11, 12 gone. Now it will take some time.
Lordship.
So by way of transfer or through upper primary selection process, SLST 2016 upper primary,
That is
teachers are to be allotted to in favor.
That is continuing. Well, that board cannot allot to which school, which teacher. is to
Have
be
you
selected.
submitted the vacancy before the DI?
No, my lord, we sent it to the SCST department for authentication.
They cannot do it. They have done
Has to
wrong
be sent to
thing.
the DI.
They have to send the vacancy to the DI. Now DI will decide, my lord, which teacher is to be sent where. And accordingly.
How many teachers are there in the school?
My lord, at present there is 24 permanent teachers.
24 teachers are there.
Yes.
Against the vacancy?
At present there is my lord, 16 existing vacancy in upper primary and 3 existing vacancy is the higher secondary section.
Upper primary recruitment is going on, my lord.
So therefore, upper primary recruitment is open.
Yes.
Why you have show me that you have forwarded the vacancy to the DI?
It was not sent. We are under.
Why you have not?
For authentication.
So let me dispose it of granting you leave. Granting you leave to forward the vacancies, existing vacancies to district schools, and DI shall take steps in accordance with law for filling up.
This is the
The authentication by the DI is not necessary.
That's what the procedure.
Affidavit of service.
Yes, madam. This is the
Affidavit of service filed on behalf of the petitioner is taken on record. Teacher in charge of Kolia Amir Ali High School within bracket HS close bracket Howrah, herein after referred to a said school, has approached this court with the present writ petition for filling up the available vacancies of assistant teachers. In the said school or assistant teachers, stop. It is submitted by the land advocate representing the petitioner that in the said school at present 24 teachers are working, but 16 posts in upper primary section and 16 posts of assistant teacher in upper primary section and 3 posts of assistant teacher in higher secondary section are lying vacant. Stop. the petitioner has prayed for authentication of 100-point roster by the District Inspector of Schools within bracket AC Howrah for filling up the existing vacancies. Next paragraph. Ms. Bhattacharya, learned advocate representing West Bengal Board of Secondary Education, has submitted that in terms of the in terms of the existing norms, at present, vacancy position is not authenticated as per 100-point roster by the District Inspector of Schools within bracket AC concerned, but it is done by the backward class department on reference being made, or on reference being made by the concerned authority of the West Bengal Board of Secondary Education. Stop. According to the respondent authorities, including board, school, instead of waiting for authentication of vacancies as per 100-point roster, is said school said school instead of said school authority instead of waiting for 100-point roster, is required to forward the vacancy to the vacancy report to the to the District Inspector of Schools AC Howrah for taking necessary steps. Next paragraph. Stop. It is also submitted that appointments of assistant teachers in upper primary level of school, in upper primary sections throughout the state of West Bengal will start soon in connection with first SLS state level selection test 2016.
Already started. Already started.
কি বললাম? It is কি বললাম? Is going on based on the panel prepared or based on select list prepared by the concerned authority of the West Bengal Central School Service Commission on concluding first state level selection test 2016 upper primary. Next paragraph. In view of aforesaid situation, leave is granted to the petitioner to report report vacancy position of the said school to the District Inspector of Schools AC Howrah, being respondent number 4 by 4 weeks from date, or by fortnight from date. Stop. On receipt of vacancy report, the respondent number 4 and other concerned respondents are directed to take necessary steps in accordance with law for filling up the existing vacancies of the states, existing vacancies available in the said school. Next paragraph. Writ petition stands disposed of urgent. Next.
Item number 20.
Yes.
My lord, the petitioner came before your lordship previously on medical ground transfer. Lordship directed the commission to take a decision. Commission issued a recommendation in my favor to the third preferred school, while first two schools are still vacant. I prayed before the authority.
First two schools are
still vacant, which were my first two preferences. Now I made an application before the authority for re-recommendation. Since my first two preferences are still open, then why I should be sent to the third school, which was at the bottom of my.
But is there any rule that if vacancies in first two preferred schools are lying, you cannot be recommended for third preference
I
school?
tell you, lordship, because at the time of giving the preferences, preference 1, preference 2, preference 3, in this way in the portal it comes. So I have the option to take the schools and put it accordingly. My lordship may be pleased to recall, your lordship has found in many matters where the SSC says by rejecting the transfer application that you are at the second rank for which this school has not been given. You are at the third rank for which lordship has seen. If that is the situation, if logically, by reverse logic, then this should not have happened. You can reject me on the ground that I am at the second rank, that's why you are not giving me that school. I am at third rank, you are not giving me at that school, even though those candidates have not even
Those position has not been disclosed.
No, only
where is the order of the commission?
Yes, my lord. Kindly page 92.
92.
Pursuant to your lordship's order. This is the recommendation. But no transfer order has been issued after this. Page 93.
It's a recommendation.
It's a recommendation
Yes.
pursuant to Lordship's order.
The submitted report, Mr. Bandyopadhyay, that why petitioner was not considered against the vacancy in first preference school and second preference school, and straightway recommended for transfer in a vacancy in third preference school.
93 is
Next,
my
submit one thing, Malad.
Yes.
Malad, the first school, Malad, where petitioner wants to join, Malad, present number of the student is 2. Existing of teacher is 3. This is the situation.
No, in subject there
In the first preference school.
First preference. Second preference school, that is the Vijay Ram Girls High School. Present number of student is 25. Existing teacher is 3. For this reason, Malad, he has been transferred in that school.
But in Bengali there are vacancy subject.
Maybe, but pupil teacher ratio does not permit your transfer.
No, for that people teacher ratio in the present school, from where it will not be allowed.
No, but in the school where you are seeking transfer, no further teacher is required.
Only 2 students.
No, well, there are
3
vacancies
teachers.
in the subject.
Maybe,
And those
but there are no students.
But it is not possible for me
In
to
terms
know.
of rationalization of posts, no, it is not required.
It's not possible for me to know at the time of when it is.
So
in the
no,
portal.
yes, you have done this,
I have
but it is
applied.
possible for this. That's why this position has been taken.
Yes. So
This decision has
Not
been
claim
taken.
on this basis I have given preference.
Instruction. I need to
So
take
this is the
instruction.
situation.
So you file a report.
Yes.
Yes.
Let it file.
Then you file state DI to file a report.
Yes. I'll also come with instruction.
Because I have received the instruction in the morning.
2 teachers,
2 students.
first school, 2 students,
3 teachers.
3 teachers.
Second school,
Give me that instruction.
Malad, this is just my handwritten, Malad. In the morning I have received.
Very well. Let it go. I will also take instruction whether it is.
Issue. In the writ petition, affidavit of service filed on behalf of the petitioner is taken on record. Stop. In the writ petition, a recommendation memo dated 7 March 2025, issued by the Secretary, West Bengal Central School Service Commission, thereby transferring the petitioner from Pahalanpur High School, Purbo Bardwan, to Adarsho Balika Vidyalaya, Purbo Bardhaman. Adarsho Balika Vidyalaya, Purbo Bardhaman, page 92 te page. Is questioned on the ground that the school where petitioner has been recommended for transfer is third preference school in terms of transfer application of the petitioner, and in other 2 schools which are first preference and second preference schools, posts are lying vacant, but the petitioner has been recommended to a post in third preference school. Next paragraph, Mr. Chattopadhyay, learned additional government pleader, represents the state respondents who on instruction submits that in first 2 schools or in that in first preference school there are less number of submits on instruction submits that in both the schools, that is first preference school and second preference schools, there are less number of students. As a result whereof, petitioner might not have been recommended for transfer to those schools. Next paragraph. District Inspector of Schools AC, Purbo Bardhaman. AC Purbo Bardhaman, being Respondent 5, is directed to file a report in the form of affidavit disclosing teacher pupil ratio or pupil teacher disclosing the pupil teacher ratio, pupil PUPI ভুল করেছিল একবার, PUPI pupil teacher ratio in first preference and second preference schools as opted by the petitioner in her transfer application. Stop. Let such report be filed by 10 days from date, by fortnight from date.
Because-
Stop. List the matter under the heading motion on no. On 30th April 2020.
Get.
Next. হ্যাঁ হ্যাঁ on backward class table. Backward class and welfare department. বুঝলি তো?
Yes, yes. Only
BKWD. Backward
BW.
class and welfare department.
Backward class department.
Item number 21.
Interest on gratuity.
List the matter under the heading
21, 22, and 23.
one after another. List the matter under the heading list the matter under the heading interest on gratuity in the monthly combined list of May 2025. Yes, that means not primary.
Lord, I appear.
Only for primary, another separate heading.
Item number 22.
I am for state.
Same order. Yes, enter your record.
Item number 23.
Same order.
I am for the statement.
Item number
Not taking any matter interest on gratuity matters from the supplementary list. That's why I am placing those matters in the combined list. Yes.
Item number 24.
Yes.
I am for the statement.
Another statement led by Mr. Bosumoli.
Okay. Yes.
Segregation.
Was transferred from one school to another, a medical group. Our grievance is that the service book has not been finalized in the earlier schools and forwarded to the present school.
When petitioner was transferred?
He joined on 1st August 2024.
1st August 2024.
There's an order of court.
But the previous school is not forwarding service book and other.
She is in regular touch with the
previous school.
in charge of the. There, she is facing certain difficulties.
1st August 2024.
He is joined on that. But the difficulties that she has faced, have been summarized in a letter that her advocate has addressed. It concerns certain orders of the Honorable High Court, pursuant to which she got financial benefits, like a long special leave on medical grounds with the full pay. But the headmaster was suspended because he denied the petitioner her due service benefit. And the service book was in a totally incomplete condition. The teacher in charge, maybe because of her inexperience and because she.
Then that school is required to be heard.
Yes.
So have you served notice upon the school? When?
Handed over the service.
Yes, please find it out, Mr. Chatterjee.
I'm copying.
Yeah, আচ্ছা দাদা ওনার কাছে কপি আছে।
At least 7 days ago.
Which page of your supplementary affidavit of service?
Page 5. The one from Televipara, page 4 and 5.
3rd of April.
On 3rd April.
You are now working in respondent number 7 school.
I'm working in respondent number 7. The teacher in charge of the concerned
So very well serve another notice upon the school authority. Let me see.
So if the service book is brought to court, the
Yes,
problems
yes.
will.
Any instruction?
No, my lord, no, sir. No, just a minute, my lord. এটাই দিয়েছে কি দিয়েছে? যে ও
There's a repeated.
As per report submitted by the school authority, the petitioner refused to sign in the service book, mentioning some error in the service book. The school requested her to sign again after rectification of errors as pointed out by the petitioner. The petitioner also demanded to provide her a copy of the all resolutions of the school's managing committee relating to stoppage and starting of salary. On 28/2/25, she went to her previous school for getting her service book, but she left the
Affidavit of
school.
service filed on behalf of the petitioner is taken on record.
This is the correct.
Grievance of the petitioner is, though she was transferred from her previous school to the present school with effect from 1st August 2024, but till date, service records of the petitioner pertaining to service rendered by her in Telenipara Mahatma Gandhi Vidyapith High School within bracket HS close bracket Hooghly has not been forwarded by the said school authority. Being respondent numbers 5 and 6. Next stop. Next paragraph. In spite of service of notice upon respondent numbers 5 and 6, those respondents are not represented. Stop. Considering the grievance made, considering the case made out in this writ petition, court desires to hear authorities of Telenipara Mahatma Gandhi Vidyapith High School HS. Stop. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon authorities of Telenipara Mahatma Gandhi Vidyapith High School HS, Hooghly being respondent numbers 5 and 6 by 7 days from date, and file further affidavit of service on the next date. Next paragraph. List the matter under the heading, under the same heading on 30th April 2025. Next paragraph. Or list the matter under the same heading on 23rd April 2025. Stop. However, it is made clear in spite of service of notice, if the school authority, if respondent number 5 and 6 are not represented, matter shall be heard in absence of the respondent authority, in absence of the said respondent authorities. Next paragraph. State respondents are represented by Mr. Bishwabodhu Bosu Mollik, learned additional government Peter. Stop. District Inspector of Schools AC Hooghly, being respondent number 3, is directed to submit a report.
This report I have tried.
Is directed to submit a report, or directed to submit a report as to why till date service records of the petitioner pertaining to the service, pertaining to her service as assistant teacher in Telenipara Mahatma Gandhi Vidyapith High School within bracket HS Hooghly are not forwarded to the present school of the petitioner.
This has been lastly.
Let such report be filed on the let such report be filed by 10 days from date. Stop. তাহলে ওটাকে করে দাও 30th April করে দাও 30th April.
If the DI is countersigns, and that is
No, Milord, DI has said, Milord, lastly, Milord, because, Milord, she has not signed in the service book. That's why, Milord, the school authority has informed him that they have not sent to the school. Lord, I shall.
30th April, not 20. Because some time has to be accorded to the DI for preparing report. Because in most of the cases, it is found that the schools, in spite of service of notice, are not represented.
Not represented.
Then travel starts.
I shall, Milord. এটা কি, এটা তো এই তো হুগলি দিয়ে হুগলিকে বলছি রিপোর্ট দিতে
4টে ম্যাটার
রিপোর্ট নিয়ে নি।
The next 4 matters are similar matters. You have any attention matter.
Why you are mentioning? This is not a mentioning time.
মাথা খারাপ তোমাদের নাকি? এই টিকেটটা
Yes, call the list.
But if is that matter may not, but I have got the report, sir. But I find the exception is required.
Let me see the report. Yes, you
File the report, my lord, on the last report.
which paragraph?
My lord, paragraph 3. Starts from.
By filing an affidavit, what you will improve?
And this is the answers, my lord, which is followed.
23 Madhyamik examination, in the meeting of the examination, copy has been given to him.
Yes, copy of this.
Of this report.
That
No,
cannot
no,
be given.
of this-
Yes,
that-
yes.
Only the copy of the report.
Yes, that
Yes,
will be
yes,
given,
yes.
not beyond that.
On what basis they have secured the submission
Yes,
that
yes.
has not been supplied to Myanmar.
No, my lord.
Court will
No,
not
no.
consider, court is not the subject expert. It is not possible for the court to enter into this. It is not possible. It is not a correct expression is not possible. But it is. It should. Court should avoid to enter into the domain of the subject expert, as it has been held by the Supreme Court in Vikas Gupta.
Certainly, by humble submission before your lordship is there. Paragraph 3, it has been said, may I read it? Paragraph 3. I state that for Madhyamik examination 2023 under supervision
Well,
board and
Vibhag ko, well, the first page, the answer is there. না না তোমায় দেবো না, এটা আমাদের অত্যন্ত গোপনীয় লেখা আছে, এটা only for the
This is which Vibhag? Vibhag?
oh বিভাগ ক, বিভাগ ক, my lord, এক, and your lordship will find the correct answer, the 1.1 ঘ, yes, গঙ্গা কিশোর ভট্টাচার্য।
এসো।
Your lordship, kindly hear me for a moment.
Yes.
Before passing down. It has been said that for preparation of the selection of correct answer subject history, thereafter the said expert opinion was placed to all the head examiners for discussion and finalizing the subject instruction on 5th March 2023 in presence of 152 head examiners. The correct answer of subject history was finalized in all head examiners meeting in the subject history. Thereafter, the subject instruction was distributed to all the examiners through all the head examiners with a clear instruction to follow the same for evaluation of answership in the said subject instruction history. The experts of the said subject selected option Gha, Ganga Kishore Bhattacharya, to be the correct answer for question. But my humble submission is this: there is some basis, there is single book should be there. Let them show a single book where from they have collected the only the expert opinion without any basis. The expert, if the expert opinion is final, and the expert opinion should be on the basis of something.
Anything more? Anything more?
And three other.
Don't repeat your submissions. Anything more?
Three other questions are there, my lord. That is.
Yes. In terms of the order dated 10th March 2025.
And my lord, your lordship, kindly.
A report is filed.
Allow me to file, my lord.
On behalf of the West Bengal Board of Secondary Education. And same is now, get it out. Today matter is heard in presence of the learned advocates representing the petitioner and respond and West Bengal Board of Secondary Education. Stop. Report which was filed on 3rd April 2025 in terms of the order dated 10th March 2025 is taken on record. Now is considered wherein it has been disclosed that Madhyamik examination 2023 was conducted by the board and meeting of 5 subject experts was held on 2nd March 2023 for preparation of for identifying correct answer to the questions of history. Stop. Thereafter, expert opinion was placed before stop. Thereafter, expert opinion was placed before all the head examiners for discussion and a meeting was conducted by the head examination 5th March 2023 where 152 head examiners were present. Stop. Therefore, the basis of identifying correct answer to question number 1.11. আন্ডার বিভাগ ক করবেন, হ্যাঁ বাংলায় আন্ডার বিভাগ ক is the opinion obtained from five subject experts and the decision taken in the meeting of the head examiners on 5th March 2023. Stop. In addition thereto, instruction which was disseminated to the head examiners as per expert opinion is placed before this court for consideration. Stop. Next paragraph. On perusal of such instruction, it appears that option Gh was found to be the correct answer to question number 1.11 of history paper. Next paragraph, it is submitted on behalf of the petitioner that the basis of identifying the correct answer to question number 1.11 is not clear, since petitioner has followed a particular textbook and question and answer of and the answer written by the petitioner to question number 1.11 is the correct answer in terms of that textbook.
Government approved.
Next paragraph. It is not a case for not awarding marks to a particular answer to a question of history paper. Neither a case is made out that any material error is crept in while awarding marks by the examiner at the time of evaluating history answer script of the petitioner. A dispute has been raised on behalf of the petitioner that in a multiple choice question, which is multiple choice question numbered as 1.11, against a multiple choice question numbered as 1.11, petitioner has indicated right option, but he or she was not awarded marks. Stop. On the contrary, by filing a report, it has been demonstrated before this court that answer to it has been demonstrated before this court that option to question number 1.11 as indicated by the petitioner in her answer script, is not in consonance with the opinion of the subject expert, which was finalized in the meeting of the head examiners on 5th March 2023. Stop. On perusal of on perusal of key answer as produced before this court, it appears that petitioner has not indicated correct options against question number 1.11 under Bibhag Ko in history answer script. Next paragraph. In this next paragraph, reliance is placed on the judgment of reliance is placed on a judgment of Honorable Supreme Court reported in 2021 2 SCC 309 Vikesh Kumar Gupta and others versus State of Rajasthan and others. Stop. In paragraph 16 of Vikesh Kumar Gupta Supra, it has been succinctly held by the Honorable Supreme Court that it was not open to the division bench, DB capital, to have examined the correctness of the questions and the answer key to come to a conclusion different from that of the expert committee in its expert committee. Stop. In this regard, reliance was also placed on the judgment of the Honorable Supreme Court in Richal versus Rajasthan Public Service Commission, reported in 2018, volume 8 SCC 81. It was also observed in paragraph 16 that in Richal Supra, court interfered with the selection process only after obtaining the opinion of an expert committee, but did not enter into the correctness of the questions and answers by itself. Stop. Therefore, it was declared that the judgment therefore it was observed that the ratio of Richal Supra is not relevant for adjudication of the dispute which was considered in Vikesh Kumar Gupta Supra. Next paragraph. In addition, thereto, reliance is also placed on the judgment of the Honorable Supreme Court Honorable Supreme Court reported in 2018 2 SCC 357 within bracket Ranvijay Singh and others versus State of Uttar Pradesh and others. In paragraph 30.2, it has been observed by the Honorable Supreme Court that if a statute or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet within bracket of an answer sheet bracket corona, then the court may permit reevaluation or scrutiny only if it is demonstrated very clearly without any inferential process of reasoning or by a process of rationalization, and only rare and exceptional cases that a material error has been committed. Stop. In the present case, no case is made out on behalf of the petitioner in order to substantiate that material error is crept in while awarding marks to answer to question number 1.11 in history paper, and no ambiguity is found so far. Opinion of the expert, which is disclosed by filing report as well as key answer. Stop. Next paragraph. Therefore, no relief can be granted to the petitioner and writ petition stands dismissed. Original copy of answer key is returned to the learned advocate representing board. Urgent Xerox certificate copy. Next.
Item number 30.
The petitioner, there was a direction upon the state to file a report.
No, this is the report.
Yes.
Yes, report the report. Yes, have a copy of one. Yes.
একটাই কপি আছে। নাম দিয়ে জানান নাম বলেছিস হ্যাঁ বলে ঠিক আছে
চলিয়ে থ্যাংক ইউ ঠিক আছে এটা কই হবে দিল্লি
না না কপি নেই তো
So the reason which has been granted, because state is required for appointment of assistant teacher in upper primary level of schools, not for classes 9, 10, 11, 12. Now, it is stated that it is reported that since there are certain litigations and legal complications over there, and 2016 selection process upper primary could not be brought to logical conclusion, as a result whereof state could not be conducted. But conducting or concluding selection process, that is first state level selection test 2016 upper primary, is not related to holding of state. if you hold the TET and if the candidates are made ready, then in the next selection process, it would facilitate the appointing authorities to conduct the selection process fast and smoothly.
Lordship.
So why this is being related? It is projected before this court that holding of TET depends upon conclusion of ongoing selection process.
Because, my lord,
Because these are not interrelated issues. Only requirement is this: for appointment as an assistant teacher in upper primary section, TET qualification is essential.
Lordship.
So why you are not holding TET?
But it would be, my lord, conducted, my lord, very soon. That has been written, my lord.
No, you have to come up with a definite instructions and indications in your report that when you will hold the TET. Last TET was held in 2015, and as per guidelines, in each year TET is required to be held.
My lord, if your lordship kindly reads, my lord, the report, my lord, from APA.
Is there any provision, Mr. Mitro, that after conclusion of ongoing selection process, only TET can be conducted?
That is
Answer is no.
Yes.
If that is the situation, why you are not holding TET?
It would be held, my lord, as
Because
soon as
if this appointments relating to SLST 2016 upper primary has started on the basis of the recommendation,
Lordship.
now it will be concluded soon. Then you will hold TET.
Yes.
Then the selection process, it will take long time.
Lord, their prayer is
So
to
this, and the teacher and the schools are reeling under shortage of staff strength.
Yes.
So therefore, why you are not holding TET?
But we will be holding, my lord, as soon as these appointments are cleared, my lord, completed. We would hold it.
Number of teachers and the staff strength in the school is abysmal.
Yes.
So now at this stage, if you do not hold TET and facilitate the selection process, then the entire proceedings will be entire process will be out of gear.
Yes, but my lord, it is reflected in the report, but my lord, that we would.
Nothing is reflected from this report. It's a very vague report.
From the top fourth paragraph, your lordship.
Yes, place it. Let us read. Let us hear you. Place it loudly.
In the year
1, 2, 3, 4. Fourth paragraph from the top.
Lordship.
After completion.
The third paragraph.
Yes.
It says, in the year 2024, after getting free from litigations, the appointment of qualified candidates for upper primary section has been started, and process is yet to be over. That is not completed. As the entire process was under litigation, and as the appointment of qualified candidates on the basis of TET 2015 is still running, the process for conduct of the next teacher eligibility test for upper primary section could not be started.
How this is interrelated? That is what I am asking you,
Lordship.
having seen this report. Yes, you are correct that SLST 2016 upper primary could not be concluded because of there are certain litigations, certain directions were passed by the coordinate benches and the honorable division bench. Ultimately, it is about to be it is to be concluded soon. Now, in the meantime, why you are not holding it?
The next paragraph is very important. After completion of ensuing appointments process for upper primary section, the state in school education department may be in a position to consider for conducting next state for upper primary section.
Why? That is why I am asking you why. Because this is not related. Is there any provision in the rules
There is no such
that
provision.
after conclusion of the selection process, ongoing selection process, then only TET can be held?
There
And
is
in
no
the
provision,
in the
but
backdrop of facts that for the last TET was held in secondary TET was held in 2015.
Lordship.
And what is the guideline?
No, this is the views of the Lord.
What NCT is saying? Clause 11 of guidelines for conducting TET, appropriate government is required to conduct TET at least once in every year.
Lordship.
So why you are not holding for last 10 years? Page 32.
Yes, my lord. Paragraph, my lord, point number 11.
Yes.
Yes.
This is the guideline.
My lord, we would
Guidelines for conducting teacher eligibility test. What does it say? Appropriate government should conduct TET at least once in a year.
Lordship, my lord.
The validity period of TET qualifying certificate for appointment will be decided by the appropriate authority.
Lordship.
So, for last 10 years, you have not held TET.
My lord, we
Now
would
you are
hold-
saying that there were litigations the process of 2016 could not be brought to logical conclusion. So therefore, after conclusion
But
of
soon
that
after its
selection process,
completion, my lord, we
the
start.
government will hold.
That is the
So
view
what
of-
is the reason behind it? What is the rationality behind this? Which is not in consonance with clause 11 of the guideline.
This is the view. of
And
the-
now the process has started. Why you are not holding it? At least the candidates can be made ready for the next selection process.
Lord, we would come with my lord, a concrete suggestion, my lord.
The report is not exhaustive, Mr. Mitro. You will not get rid of this court by filing this vague report. It has to be in consonance with clause 11, though it is a guideline and its language is that the government should, not shall, but at least an effort has to be made. For last 10 years, you have not done anything.
Lord, we have said in this report that
Only trying to accommodate some of the candidates in connection with the selection process, which was going on and conducted by the West Bengal Central School Service Commission.
Yes.
That is separate. That is not neither here nor there so far this writ petition is concerned. But why you are not holding TET for last 10 years?
Lord, we would hold it. Lord, explanation is given. We would hold it. Lord, as soon as the Lord, that appointment process is over. Lord, we would hold it. Lord.
File an affidavit, report in the form of affidavit by the commissioner to file a report. And that has to be in consonance with clause 11 of the guidelines.
Lordship.
And you have to demonstrate before this court that how the ongoing selection process, that is SLST 2016 upper
How it is
primary,
relevant.
is relevant in the matter of conducting TET.
But in this report, Lord, the view
Yes,
of the respondent is this, Lord, we will hold it, Lord, as soon as that appointment process is over.
You have to, yes. Do you want to submit anything? Matter is heard in presence of the learned advocates representing the petitioner, West Bengal state respondents and West Bengal Central School Service Commission. Stop. In terms of the order dated 13 February 2025, a report dated 3rd March 2025, prepared by Commissioner of School Education West Bengal, is placed before this court and same is taken on record. Next paragraph. On perusal of the report dated 3rd March 2025, it appears same is inexhaustive. Stop. An effort has been made by the commissioner to satisfy the query of the court satisfy the query of the court by stating that first state level selection test 2016 within bracket upper primary is not concluded or is not brought to logical conclusion, and after conclusion of the said selection process, steps are to be taken for conducting TET. Stop. Next, stop. In next paragraph, attention of this court has been drawn to clause 11 of guidelines for conducting teacher eligibility test within bracket TET issued by NCTE, by National Council for Teacher Education, within bracket for short NCTE. For better understanding of the issue, next paragraph, for better understanding of the issue, clause 11 is quoted below. Next paragraph. In consideration of clause 11, it appears that appropriate government was advised to conduct TET at least once in every year. Stop. In the present case, in the state of West Bengal, no TET was conducted after 2015. Therefore, stop. Therefore, it transpires that for a period of 10 years, no TET has been conducted by the concerned authority, by the concerned state authorities. Stop. On the spacious, next paragraph, on the spacious plea of ongoing selection process, that is first SLST 2016 upper primary, which is yet to be concluded. state authorities cannot sit idle and avoid its responsibility in the matter of holding TATE. Stop. Next paragraph. In view of aforesaid scenario, leave is granted to the learned. Commissioner of School Education West Bengal is directed to file a report in the form of affidavit disclosing when TATE is to be conducted, when the next TATE is to be conducted, taking into consideration that for a period of last 10 years, TATE has not been held, and there is specific guideline as contained in clause 11 of guidelines for conducting teacher eligibility test within bracket TATE, where it has been prescribed that the government should conduct it at least once every year. Stop. Next paragraph. Let such affidavit be filed by fortnight,
holidays are intended.
by 3 weeks from date, with an advance with a copy upon the learned advocate representing the petitioner. List the matter under the same heading on May 2025. You have to come up with a specific indications that when you are going to hold TATE.
Only one thing, on the last occasion when the matter was taken up, since they initially did not appear, there was a layer after I came below. The director upon the lawsuit sought notice. After my learned friend appeared and mentioned this matter. Your lawsuit actually no notice is required to be given, but since I have not prepared the notice, but there was an order, that is why I did not prepare the notice under your lordship order. We came rushing in.
They have filed and replaced. Situation has been changed.
Lordship. Item number 31.
I appear on behalf of the petitioner, merit at the cost of admonishment.
Yes.
Merit, as per the last order, I was directed to file an exception, merit. The exception is ready, although it's not been affirmed. Therefore, merit, I seek one.
There was a direction to file an exception.
Merit, I seek 1 week of adjournment.
At the time of call, learned advocate representing the petitioner has prayed for extension of time to file exception to the report filed by the commission.
Yes.
Exception to the report filed by the West Bengal Central School Service Commission. Stop. Hearing of this matter stands adjourned till 29th April 2025 in order to enable the learned advocate, in order to enable the petitioner to file exception. Next.
Item number 32.
For the state. Last occasion, my lord directed me to file a report.
So, mistake access. That's good. I don't it's good of okay, there's some questions. That's why
Yes, report by the
Well,
day.
report have
Which paragraph?
my lord, paragraph is paragraph 5 and paragraph 6. My lord, the petitioner wrote two letters. One
Just a
of
minute, just a minute.
Paragraph 8.
Yes, paragraph
8.
8. So this pay downward fixation of pay was made with a memo dated 26 November 2020 by the District Inspector of Schools, whereas you have retired on superannuation in 2024 31st of December. So that is beyond the time as contained in the judgment of Rafiq Mashi.
No, that will also can you see first, second line. Indian Joint Director, Deputy Assistant Director of the Accounts, by dated the 30th September 2019. That is the in my favor, not made objection. That is
No,
the-
it is stated, place it in its entirety, paragraph 8.
I further said that the petitioner had completed 18 years service on 4th February 2019 and Gideon Joint and Deputy Assistant Director of Accounts, Kolkata, filed letter dated 13th September 2019.
Made objection.
Made objection, not made objection in my favor. Well, that is the annexure. My lord.
Objection in your favor.
Yes.
So what then?
31.
What?
That
Why
is
objection
why,
was
on
raised?
the basis of the objection of the Joint Director, I was drawing till my retirement.
Made objection against 18 years service benefits.
Pardon me. You will also kindly see.
Made objection against 18 years service benefits and also find out such anomaly of providing double increments in the year 2011. That was the contents of the objection. In spite of not having any training qualification.
Where is the 13th September?
Subsequently, the TIAC Kolkata with memo number 930M dated 26 November 2020 had refixed the pay of the petitioner at rupees 19,040, 19,040 in place of 19,320 as on 1st July 1990. So steps are taken within time.
13 September 2019.
Do you want to file any exception to this, report to exception to this? Or I'll decide on this?
13 September 2019.
I am asking you, don't waste court's time. Then I will not hesitate to decide this. But do you want to file any exception?
Then
After hearing 15 minutes now, then when I will be about to start my dictation, then you will pray for exception that I will not entertain.
that is 13. My lord, earlier.
Do you want to file an exception? Issue. In terms of the order dated 27th February 2025, a report in the form of affidavit has been filed by the District Inspector of Schools AC Kolkata and same is taken on record. Next paragraph, Mr. Jana, learned advocate representing the petitioner has prayed for opportunity to use an affidavit taking exception to this report. Stop. Let such affidavit be filed by fortnight from date with a copy upon the learned advocate representing the state respondents. Next paragraph. List the matter under the same heading on Sixth May 2025. Next.
I am actually from the full authority that will probably be given to me.
Yes, yes. Enter your appearance, copy the exception which you will file.
Item number 33.
Well, in 33, there was a lordship's order so that we send it to a expert and get a report on that. Well, that was done. During the Ramjan period, there was some delay. I am told, my lord, today they are almost completing it. I'll be
That report.
Yes, I am only seeking, my lord. They said the next week, my lord, there are only 2 working days. There will be some difficulty for affirmation.
Why? On 16th, I will hear you.
No.
On 16th, come.
So,
the judges will be there. Members of the bar will
No,
be there. Why you have difficulty on 16th?
I don't have difficulty. I said that, well, I have been told that it is almost in completions.
So almost complete today, you are saying.
True.
Today we are on 8. Then there are 3 working days left.
True.
9, 10, 11.
True.
So let it be on 16th.
16th, I want your lordships to have a different.
Other matter.
I'll keep it on. Can you give us 2 weeks time?
All the learned advocates are praying for time on 16th and 17th day.
No, I am not.
Nobody
going,
will come.
I am not going anywhere. I'm not that much.
Whenever I am about to fix a matter on 16 and 17, objections is.
But that is mentally we want to give a projections that as if we are free.
At the time of call, Mr. Pratik Dhar, learned senior advocate representing West Bengal Board of Madrasa Education. Hey, West Bengal Madrasa Service, representing West Bengal Madrasa Service Commission has prayed for extension of time to file report in terms of the order dated 4th March 2025. Stop. However, stop. Next paragraph. Petitioner and state respondents are represented by learned advocates. Next paragraph. Time to file.
16th, lordship may keep it on 16th.
Time to file report. Time to file report stands extended by 7 days. Stop.
But the advance copy was
Yes,
rejected to me.
It would be. As soon as they would.
List the matter under the same heading on 22nd April. Because 7 days will not be.
22nd is that, my lord, group D.
Very well, on 23rd.
16th, I will be coming. I have no difficulty.
No, but 7 days will not be concluded on 16th.
In that
intervening holidays will
yes,
be.
yes, 23rd.
23rd,
yes,
not 22nd.
Yes.
Applies.
Next.
Item number 34.
Yes, affidavit service. School is not represented.
Already when I DI,
I think, my lord, the school is not, my lord, in absence of the school, that matter can be disposed of.
Yes.
My lord, I have not challenged the selection process of assistant headmaster.
You are
not
praying for
postpone interview.
initiation of fresh selection process.
Yes, in
For filling,
place of
filling up the post of assistant headmaster. Yes.
No, just before that, you will
Yes.
also kindly see page 75. Just, my lord, page 75, you will also kindly see. Page 75. 8037. Page 79.
Just a minute.
Para 5 of the.
Page 79.
No, page 75.
Just a minute. Yes, yes.
lost 5 taken me. Papel দিচ্ছিল তো। মনে হচ্ছে তো।
Now the page 79, para 5 of the rules.
But it was not informed by the head of the institution to the DI.
Yeah,
As it appears from page 75.
Page 79, you will also kindly see para 5. What is the procedure rule?
Page 79.
79.
Yes.
Para 5.
Paragraph 5. One, the date of interview for the post of assistant fixed up. So approval is necessary.
Yes. Well, I don't know whether the DI has given approval or not for
But a report has to be furnished by the head of the
that is
institution.
also not given by the headmaster. Intentionally, well, the assistant.
So you file a report as to why till date.
Well, a hearing was read in the office of the DI, headmaster and managing committee members were present. DI specifically stated the take immediate resolution and fixed a date. But since then they are not taking any action against the.
So when I file a report in disclosing this, then I will take steps against the school authority.
Well, let you kindly go through the second paragraph.
Bring it on record by filing an affidavit. By filing a report. Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice, authority of Rangamati Kiranumoi High School within bracket HS, Paschim Medinipur, being respondent numbers 4 to 6 are not represented. Next paragraph. Petitioners are praying for a direction upon the concerned respondent authorities to hold a de novo interview for filling up the post of assistant headmaster in the aforesaid school. Stop. The next paragraph, the district inspector of schools AC Paschim Medinipur, being respondent number 3, is directed to file a report in the form of affidavit disclosing whether steps have been taken by the district inspector, disclosing what steps have been taken by respondent number 3 as well as the aforesaid school authority for holding de novo interview for the post of assistant headmaster. Stop. Next paragraph. Let such report be filed by fortnight from date. Stop. Next paragraph. By fortnight from date, and a copy of the said report be served upon the learned advocate representing the state, representing the petitioner. Next paragraph. List the matter under the same heading on.
Well, it's 2 weeks because coming week
Fortnight I have said.
coming week totally
This
close.
is short issue. Fortnight. I have said fortnight. Paschim Medinipur fortnight. Enough time. List the matter under the same heading on 29th April 2025. Call the fixed matter.
3 p.m. fixed matter, item number 35.
Now I have to hear it in depth.
We tried to.
Though there is a detailed decision by the Honorable Division Bench. View expressed by the Supreme Court is otherwise.
Quite often, we have followed the practice, appearing either for the petitioner or the respondents. But I have a comprehensive list of dates prepared with reference to the pagination in the SLP and the counter.
Yes.
If your lordship so permits, I can hand up copies of the SLP and the counters for convenience, because that is bound volume and that will be easier and convenient for your lordship to handle.
Hand it up.
But I'll do that, but not just for recollection.
So all the facts are to be all the facts are to be considered from that.
So that your lordship may not have to rummage through all the voluminous documents and one affidavit to other. These are all compiled in volume.
Yes.
But this is a case for compassionate appointment in GRAC Limited. The controversy.
Shipbuilders,
Shipbuilders and Engineers Limited. The controversy started with reference to a 4th phase of recruitment in labor class, in classification of laborers.
Under compassionate ground.
Under compassionate ground. Now a vacancy was declared. Quite unlike other cases, claimants under compassionate appointment scheme have to undergo a process of recruitment along with the other vacancies notified vis-a-vis the recruitment process. Normally one expires and the eligibility is considered and taken in employment. But not in this case, they have to wait till the company decides to fill up the vacancies. But in this process, 3 rounds or 3 stages of recruitment process or drive had taken place, and from a panel, 179 were already appointed.
Yes.
170.
170.
170.
170.
170 had already been appointed from a panel.
Yes.
You also release other matters. Because the very next matter is of mine. In the.
Yes, I will hear this.
Then you'll also release. Much better.
Now, this, when I refer to the panel of 249, I refer to the panel of applicants under compassionate appointment scheme, not a panel for other candidates. So we were waiting on the line, and
awaiting the next phase of recruitment to come over so that we could also be appointed in the vacancies. And at that stage, the company kept the process at fourth phase in abeyance because
in first three phases, 170 were appointed. Fourth phase was remaining due.
Fourth phase, up to a certain length of exercise was undertaken, the process was kept in abeyance.
Just a minute. Yes.
There were settlement or say minutes of meetings. The company couches this as a minutes of meetings, which were regulating the eligibility vis-a-vis the process to be followed in dealing with cases of compassionate appointment. Now, those were from 1979, 1999. Writ petitions were filed. Orders passed that those petitioners be given a preferential treatment. Settlement was executed in 2001, which the company now says it's a minutes of meeting, not settlement. And all these things are there, but not principally those were governing the field of compassionate appointment till the third phase, admittedly, even up to a certain exercise undertaken at a particular point of time in the fourth phase. Now, when the fourth phase was kept in abeyance, the company cited there is a vigilance complaint. Vigilance has objected to the process.
Yes.
Now, this keeping in abeyance in 2009 came at a stage when
yes,
the applicants had already been interviewed and their economic viability had also been examined through a door-to-door inquiry. Because at that stage, the process got to be stalled. So a writ petition was filed by my clients directing expeditious conclusion of the recruitment process. Or say, whatever may be, you complete the process. You don't keep it in abeyance for eternity. Now, to that, there was exchange of affidavits. The Honorable Court directed.
When this writ petition was filed?
This was filed in 2009. Shortly after the recruitment was kept in abeyance.
Writ petition number?
That was 19565 W of 2009.
Yes.
Now, even after this was done, there was pro forma given to the candidates for the purpose of penury verification, financial penury verification. Now, ultimately, this writ petition came to be disposed of in 2011.
Date of disposal?
13th of December 2011.
What was the direction?
The two directions: conclude the process within 6 months and CVC to supervise.
Central Vigilance Commission. Yes.
Now, the vigilance went up in appeal. They said, no, I don't want to keep a daily monitoring on this.
Vigilance
went up in appeal.
Process was stalled due to interference by vigilance in the fourth phase. Now, this was the direction, then vigilance preferred appeal. Yes.
Now, they didn't move that appeal. There was exchange of affidavits or applications filed. Company supported its own stand quite naturally, saying that no, everything has been done transparently. There was approved vacancies. We were proceeding in accordance with the existing norms. And the company had even written to the ministry for the purpose of expeditious disposal of the process or completion of the process. All those are on record.
Now, what was the fate of that appeal preferred?
That ultimately they didn't move it. and at that stage it rested. And the appeal was disposed of with a direction to conclude the process of recruitment within 6 months. So the appeal court really extended the time.
Yes.
The specific stand taken by the company before the appeal court in relation to an application whereby the application was filed to seek extension of time was that the government guidelines do not apply to the company.
This point was taken by whom?
Company. GLSE Limited.
In the appeal of the CBC.
The government guidelines do not apply to the company because it is a separate entity, a government company.
But this guideline was followed while giving appointment to 170.
No, the company's framed guidelines or not the minutes of meeting, whatever was the understanding.
Then why government guideline came into the picture?
The government guideline was given a shape of a scheme by the company in 2013.
So new guideline was framed. So during the process, a new guideline came. That's why I passed that order at the time of
await NC Santosh. Now
2013.
Now
so new guideline of 2013, Mr. Mujumdar? 2013.
27th August 2000.
Now, while deciding the appeal preferred by CBC, Honorable Division Bench directed to conclude the process by 6 months. Was there any observation by the Honorable Division Bench that to follow a particular guideline?
Disposed of the appeal when the new policy had not seen the light of the day.
Oh.
The appeal was disposed of on 13th March 2013.
Just a minute, disposed of to conclude the. When disposal?
13th March 2013.
New guidelines was introduced, were introduced on
27th August 2013.
Please give me the date. Which August 2013? 27th. Yes.
Now we filed a contempt application
before the division
bench because they were considering the penury condition of the families and not by cyclo-style orders, those were getting rejected. You don't have the certificate from the revenue authority. What is revenue authority? Unidentified. Cannot be filed contempt applications because in letter and spirit, the order of the Honorable Division Bench was not being complied with. So, kindly grants me liberty for the time being not to use this. We will give a compilation of this.
Yes, yes.
A copy on it. SLP একটা copy. SLP দরকার। List of SLP দরকার। কালকে পরে একটা দিয়ে দাও।
Everything is with you.
No.
The matter went from single bench to
barring
division bench to Supreme Court.
No, barring the list of list of dates which my learned friend has
Yes,
just fine. Other things are not required. Only this.
Yes.
But please come to page 4 of that list of dates.
Yes. Page 4.
Serial number 19, 13th of March 2013. Appeal
This is a division bench order.
Order.
Yes.
Then serial 22 is the revised compassionate appointment policy.
22.
22, yes.
Yes.
Now, what was the ministry's policy? There should be a reservation to the extent of 5% against compassionate appointment.
5% reservation.
Against compassionate appointment. Apropos this, the board took a resolution that relaxed this 5% reservation as a one-time
measure.
because the process had already been initiated and it has undergone a long process in the meantime. Please come to.
Now, if this would have been accepted by the government, then there was no scope left open to the petitioners to be appointed on compulsion ground, since 170 has already been appointed. So according to the stand which was taken by the GRAC is that this should be treated as one-time measure. This 5% reservation for appointment on compassionate ground.
That should be relaxed by way of a one-time measure. Please come to serial 25.
25. The board of the
This dispending should be dispensing.
Dispensing, right? Dispensing. So what actually board prayed for by dispensing with this requirement of 5%?
The resultant effect of dispensing with this 5% reservation would be all these persons would be considered or would be appointed in the recruitment drive. Suppose there are 50 persons applying against the compassionate appointment scheme. If 5% of 50%, or say 50 vacancies, I'm sorry, there was 209 vacancies. So 5% of the vacancies would be 10.
So 10 would be restricted to
this cap of 10 persons to be appointed against compassionate appointment would be lifted. So if there are 30 or 40 left,
this one-time measure theory was introduced by 27th August 2013 policy. No.
That was the revised policy of the company. But the board took a decision on 31st of July 2014.
But this has no nexus with the policy which was introduced on 27th August 2013.
The policy says what are the eligibility criteria, what should be the maximum age limit, what should be the minimum age limit.
In addition thereto, this was.
Yes.
Yes.
Now, after that, there was a report of committee on penury cases. They said that none of them had fulfilled the eligibility criteria. There was non-submission of documents or financial condition. But quite surprisingly, it appears to be an afterthought process because not the first date of the meeting took place even before the committee was constituted.
14 January 2015. The report of the committee is not good. So this was decided prior to formation of the committee.
There was one meeting held by the committee even before its constitution, as will appear from the records disclosed by the company. Therefore, I take liberty to submit that this was an afterthought process.
When the committee was constituted?
I'll just give the date. Formation of the committee took place
just
2nd August 2014.
August 2015.
2014.
2014. But this report is dated 14 January 2015.
Report is 14. In the report, it mentions about 2 sittings held prior to the date of formation. Now, please come back to the list of dates, serial number 27. The Honorable Division Bench decided and dropped contempt with liberty to challenge the committee's report.
Yes. Which date you are referring to now?
Serial number 27 at page 4.
Yes, page 4.
11th February 2016, the Honorable Division Bench decided and dropped the contempt with liberty to challenge the committee's report. So the writ petition is filed.
Present writ
Present
petition
writ
is.
petition is being.
Yes.
Now, the next page at page 5. 1st August 2016, an interim order was passed restraining filling up of 49 posts. Because there are 49 persons approaching the court.
So that regular candidates cannot be appointed in those 49.
Protect the 49 persons.
But the candidates are 170. How many petitioners?
49 approach the writ court.
As of
So
now,
there are 49 petitioners.
As of now, 49.
49.
Yes. In the 21st of February 2022 is the Lordship's order. And the matter went up to the division bench, but whatever is there, that the Lordship has already seen that.
Yes.
Now, the sole ground or the principal ground on which the company seeks to negate my claim today is that because of a new policy having stepped in, the old rules or the old policy cannot have any manner of application. That's the basic.
That was the consideration before me also.
Basic point. My first and foremost submission is, apropos the old policy and the new policy, there is no substantial difference. Nothing has been pointed out by the company thus far to demonstrate that this policy differs from the earlier one in XYZ parameters, and therefore why this cannot have any application.
New policy is new guidelines or policy 27th August 2013. Now, what was the old policy?
The old policy as such was in terms of settlements of 1999 and 2001, which laid down the eligibility criteria.
This court will get it, this old policy.
It was before the Honorable Supreme Court. That's why that paper is required.
That paper
are before the Honorable Supreme Court.
So it was not placed before the Honorable Division Bench.
Division Bench, no, in that manner it was not there. But my learned friend gave a compilation of the documents. Through that it was there. But everything has been compiled in the
Honorable Supreme Court.
Everything. No, that 99 policy was declared in the SLP by the company.
Yes, that's why. That's why.
So far the records of this case before me, where court will not find the old policy.
Only 11/5/2006, your lordship will find in the part of the writ petition and the affidavit in opposition also, that was not the policy. Our contention was it was a MOM, minutes of meeting, which my learned friends clients are telling that this is a settlement, and our contention is that this is not a settlement. This is the controversy. But all the documents which on the last occasion I craved before your lordship, that the documents which were before the Honorable Supreme Court are required to be placed to have a whole hog hearing. Entire thing is required. That's why I prayed for leave before your lordship to file a supplement. Now my learned friend, now my learned friend has already said that he will also going to rely on. So I don't think
beneficial for the bench also.
Everything for three of us, lordship.
Mr. Kaur, you are appearing for GRSC.
Yes. I am led by Mr.
লোকটা দিয়ে দিয়ে আজকে
আজকে আমি জানি নি আমি তো
সেদিনই বলেছে পার্ট অফ দ্য রেকর্ডস
দিতে হবে না
দিয়ে তুই তো জেরক্স করে রেখেছিস
এটা কম্পেশন ডেভেলপমেন্ট কেস ভাই এটা
না
Yeah, Mr. Mujumdar doesn't want to place it before this court.
No, I want.
As it appears.
Going,
says that it's a competitive.
going by the,
Therefore, he wants to keep the burden on my learned junior to prepare it. And I
going
said
by the
that-
identity of the clients, I request my learned client to bear the burden.
That he will.
Yes, they will. Yes.
Accept that.
So there is no difference. There is no a difference over the old policy and the policy dated
That's my submission.
27th August 2013. Yes.
Secondly, the panel got frozen as on 31st of March 2006. That 279 panel, 249 panel.
So according to you, the rights of the petitioners were crystallized.
And from the said panel, 170 had already been appointed. But I'm quite alive to the proposition of law that empanelment does not give a.
When this 170 were appointed?
They were appointed by 2008. 2006-7. 2006-7.
2006-7.
By 2006-7, all these 170 had been appointed from the same panel which got frozen as on 31st March 2006. No further induction in the panel thereafter.
From the panel dated?
Panel frozen as on 31st March 2006.
March 2006.
31st March.
31st March.
March 2006.
Yeah, kindly comes to the entry number 8 at page 2 of the list updates.
Entry number 8.
Yes. 1850-2174.
So you were part of this panel,
There were
out of which 170 were appointed.
The balance remained was 79, 50, 49 approached the court.
When this process was going on to give appointment to the rest of the petitioners, 49 in number, then CVC interfered, and then the writ petition and the division bench, contempt, and then the present writ petition was filed.
Challenging that report of the committee and seeking appointment.
Now, there is a judgment of the Supreme Court which was considered by this court that in the interregnum or during continuation of process of appointment under compassionate ground, if the policy gets changed, in that event the new policy is to be considered, or the policy which was in force
decided
on the date of death would be
NC Santosh.
NC Santosh is the new.
Now, to that note, there has been a lot of deliberation by the Honorable Supreme Court in various other judgments. The last one is Canara Bank.
Yes.
The second Canara Bank judgment of 2025.
After the facts, I want detailed submission on this.
Now, NC Santosh
Mr. Mojumdar first place the facts. Then you will be permitted to make submissions with regard to the law laid down by the Supreme Court on this issue.
So, not factually, till the division bench proceedings came to an end, the management was supporting its own stand, quite obviously, and saying that against declared vacancies, this process had been initiated. They had all been found to be eligible for the purpose of recruitment, and requesting the ministry to supervise through the vigilance so that the court's order could be complied with. That's all, nothing else. The delay has been now used as a handle for them to subsume my right. Up to what stage did this exercise go on in the fourth phase? Up to the stage of door-to-door inquiry and scrutiny.
And the financial condition of the
family. Door-to-door scrutiny means the financial condition.
Yes.
Now, when before the division bench in this last round, we were before the honorable division bench, the honorable division bench felt very well substantial period of time has elapsed. Why don't you consider the financial situation once again? Because of passage of time, after all, this is the primary condition for compassionate appointment. So they had once again constituted a committee for that purpose.
To assess the financial position or
In due
condition.
deference to the interim direction passed by the honorable division. But after the final judgment, they went up in appeal. Now, these are the basic and bare facts.
So what was the disclosure based on the exercise which was carried out in terms of the order of the honorable division bench?
Yes. Please come to page 5
of
the list of dates.
List of dates.
Page 5.
Page 5. Entry number
35.
Whether this order is part of record? No.
These are all part of that SLP 1 feature shall produce.
Very well. Then, yes, this is the order on 14th May 2024. Then, what was the disclosure made by the made after conclusion of exercise?
Yes, please come to serial 38 and 39 on the next page.
Just a minute.
SLP দিয়ে দে Best of luck.
Page entry number 39.
38 and 39.
38.
Seeking my lord's guarantee.
Yes, yes. Respondent file. I will not use it. What is the interim application of respondent number 11 to 47, Mr. Mojumdar? As referred to against entry number 38.
Before the Honorable Supreme Court, we filed an IA to disclose these documents.
Oh.
Supplementary affidavit is not allowed before the Honorable Supreme Court. That's the idea.
Then a committee was constituted as per order dated 25th June 2024. Then what was the observation of this committee?
But at that stage, the matter went to the Honorable Division when finally decided. Then
No. We have filed the report on the basis of the union gave us 31st May 2024. A letter was given by the union. Out of 49, 30 writ petitioners, they provided the income certificate issued by the MLA, MP or commissioner, whatever may be. That was given to the union, to the management. On that basis and based on the available records, a report has been submitted. Now, at that before the Honorable Division Bench, a question was raised by my learned friend's client that no door-to-door exercise was done by the company as of 2014 before the Division Bench. What was done?
It was based on the production of the income certificate.
Income certificate by the union. Then the Honorable Division Bench verbally observed, your client has given this thing. Then the company has got every right to rely on that. That was the thing.
I didn't understand.
That was the stage And thereafter, ultimately the division bench heard the matter, and that was not taken into consideration. Then ultimately
Final order was passed.
That was the thing.
Yes, Mr. Madhuri.
These are the basic facts, not the, if your lordship has the opposition in the brief, I just.
Just a minute, let me find it out.
The companies stand in the affidavit in opposition.
Yes, affidavit in opposition. Yes.
The lordship may straightway turn over to paragraph 6 of the self-same opposition, paragraph 4.
Page 16. No.
I'm sorry, this is paragraph 18. Paragraph 18.
Page 11. You don't have affidavit in opposition.
No, page 11. Yes.
Yes, page 11.
Not, it has a broad caption, background.
Paragraph 18.
Without prejudice.
It has a broad caption, background.
Without prejudice to the
Yes,
submissions.
thereafter the background is there.
Yes, background.
Minutes of meeting between management of GRSE and the union in the name and style of GRSE Limited Workmen's Union was signed on 1997 with regard to compassionate employment of dependents of the operatives who die in harness as per the company's record subject to vacancy. It is evident from the said minutes of meeting that amongst other conditions, inter alia, following conditions are required to be fulfilled. Please take note of the conditions. Age, maximum age shall not exceed 30 years for son and daughter and 40 years for widow of the deceased operative. So the cutoff age is mentioned. The age with regard to past cases, it will be reckoned as 30 years for dependent son and daughter and 40 years for widows as on 1st of September 1990.
Past cases means?
Not those which are before this date of the minutes of meeting. Please see the next item, very important. Qualification. Financial condition. Such employment will be provided only if there is no earning member in the family of the deceased to support the family. Cases of compassionate employment of dependents of operative died in harness would be processed as per the minutes after the same has received the approval of the board. So not all essential parameters for adjudging the claim for compassionate appointment were laid down since 1997. These are the basic criteria.
Processed as per the minutes. Yes. Paragraph 6.
But these are the three essential criteria: age, qualification, financial condition. And educational qualification also. Copy of the minutes annexed. The board of directors in a meeting held on 22nd of September 1998 considered the aspect of recruitment in the unskilled categories. So not they were to be appointed only in unskilled categories, including die in harness cases, and imposed a ban on recruitment in such categories. The relevant portion of the said resolution reads as follows. After detailed discussions, the board decided that no further recruitment is to be done in the unskilled categories, including die in harness cases, until vacancies became available. Not this ground is no longer available because the company itself notified vacancies and issued the recruitment drive. Subsequently. A copy of the communication dated 13th October 1998 enclosing therewith an extract is annexed. In the year 1999, a writ application was filed before this Honorable Court by 56 dependents praying inter alia for their appointment on compassionate ground. The same was ultimately disposed of by this Honorable Court by an order of 2001, directing the answering respondent to the following effect. It is, however, made clear that the respondent authority must consider the case of the writ petitioners as and when ban of employment is lifted by the board of directors, and as and when the respondent authority decides to fill up any vacancy, and in such event, the respondent authority will not be entitled to appoint any person without first considering the case of the petitioners and other successful trainees in such die in harness category. In such event, age eligibility bar will not stand in the way of getting such employment, although restricted to the petitioners in that case, but this is normally followed in all cases. But what is the special circumstances in this case? All these employees in unskilled categories are initially given training and then absorbed. Appointed as trainees, then absorbed in regular employment. Board of Directors of the respondent company in its meeting held on 29th of March 2005 had the occasion to discuss on compassionate appointment to the dependents of GRSC employees who die in harness, and it has been resolved to the following effect. After discussing on the subject, the Board of Directors directed the company to re-examine the proposal with reference to other shipyards and the neighboring industries in Kolkata, West Bengal, especially Kolkata Port Trust, and to reframe the policy depending upon the current trends of industry. The revised policy should be beneficial to the company's business and not purely welfare oriented. The same should be resubmitted for consideration to the board at a later date. So no reference to government. A copy of the extract of minutes is annexed. By a letter of 31st of March 2005, the general manager of the respondent company informed the petitioner number 2 about the decision of the board meeting held on 29th March 2005. The relevant portions read as follows. The issue was also discussed during the board meeting held on 29th March 2005. The board has directed to examine the issue in detail and place a suitable proposal on the subject for the consideration of the board. You would appreciate that here is a ban on recruitment imposed on the company. The scheme for compassionate appointment can only be brought into force when the vacancies arise. The solution to the issue may require time and patience, subject to lifting of ban on the recruitment and formulation of a viable policy in this regard. A copy of the letter is annexed. It is pertinent to mention that such ban on recruitment in unskilled category is in existence at present, and the same would be evident from the extract from the minutes of 329th meeting of the Board of Directors held on 2015. Should be 2005, 1711, 2005. The relevant portions of the said extracts are appended hereinafter. Recruitment in Group D category of the employees to be made with prior approval of the board. So it's in Group D. But please visualize not the chain of events. First is age, cut-off age. Second is qualification. Third is financial penury. Fourth is in which category of post this appointment is to be made. And fourth, the process. Training, completed, absorbed. So to show that the policy was changed in 2013, the company has to come up with a striking case to demonstrate before this honorable court that this 2013 so-called policy was so different from the earlier one that it required a complete sea change to be followed in the procedure. The board also, I'm reading that quoted paragraph 32. The board also re-emphasized the needs for its prior approval for recruitment in Group D category, that is unskilled category. The die in harness case basically belongs to unskilled or Group D category. A minutes of meeting between management of Garden Rich Shipbuilders and the union in the name and style of Workmen's Union was signed on 11th May 2006 on the subject of compassionate appointment to dependents of deceased employees who died in harness. Paragraph 8 of the said minutes of meeting provides as follows. The panel of dependents in the died in harness category will be frozen as on 31st March 2006 in consultation with the union. The finalized panel of dependents duly signed will be handed over to the union. Additions and deletions will not be permitted thereafter. So that's the 249 panel. As of
Petitioners are part of that frozen panel.
170 already appointed, remained 79, 50 were before this court.
Yes.
As per the said minutes of meeting, the criteria pertaining to age, financial condition, and qualification are to the following effect. Age. Maximum age of the candidate shall be governed by the rules of the company as applicable. Eligibility conditions such as age and qualifications may be relaxed in deserving cases of dependents of the deceased GRSE employees who have died in harness with the approval of the competent authority of the company. Now, please recollect that entry of 2015, the board decided that give a one-time relaxation. Financial condition. Such employment will be provided only if there is no earning member in the family of the deceased employee to support the family. There is no difference with the earlier one of 1997 or 1999. Just a few minutes back, I have read that page.
Yes.
Qualification. Applicant should have the requisite minimum qualification as per the rules of the company as applicable for the post notified or applied for.
Here it was
Class 8.
class 8. Now it is in terms of the applicable rules.
As notified. A panel consisting of 279 names of deceased employees' children was frozen as on 31st of March 2006. However, this panel has not been signed or authenticated as per the said minutes of meeting. 4 advertisements were published in dailies for casual laborers, and a total of 213 casual laborers were selected up to the 3rd advertisements, which includes 170 deceased employees' children.
Yes.
So 213 were appointed up to the 3rd phase, out of which 170 were compassionate appointed. It is pertinent to mention that the applications have been countersigned by the union representatives, which is a gross irregularity in the open recruitment process. How?
Yes.
It is needless to mention that countersigning the applications of the dependents of the deceased employees against open advertisements by the union representatives was uncalled for and unheard of. In the advertisement of recruitment, it was mentioned that applicants should have the requisite minimum qualification as per rules of the company as applicable for the notified posts. Further, it was also mentioned that maximum age of the candidate shall be governed by the rules of the company as applicable. Undisputedly, there was no codified recruitment rules at that material point of time. Eligibility criteria were mentioned to be as per the rules of the company, which is vague and incorrect. But the company is saying so.
Their rules are vague. Yes.
No, not rules are vague. At that point of time, we don't have any recruitment rules.
No, I am going by an
That-
affidavit
So
signed
that's
by a general manager of a company.
There were no specific rules according to very well. Yes. Go ahead.
But I read once again. Eligibility criteria were mentioned to be as per the rules of the company, which is vague and incorrect. It's signed. This affidavit is formed by a general manager of the company.
the fact.
So he said incorrectly. The candidates may not be expected to have access to the company's policy unless the same is made transparent in the advertisement itself. Very fair. Age and qualification criteria were not specified in the advertisements, but in the same advertisements, it was mentioned that age and qualifications may be relaxed in deserving cases of the dependents of the deceased employees with the approval of the competent authority of the company. Central Vigilance Commission's intervention and consequential effect. Consequent upon receipt of various allegations of irregularities in recruitment of DI candidates in February 2009, the Ministry of Defense appointed a board of inquiry to investigate into the allegations in the recruitment process of casual laborers in the company. A copy of the order dated 26th of February 2009 is annexed. By a notice dated 9th of March 2009, the management of the company informed all concerned that the 4th phase of recruitment has been held in abeyance pending inquiry ordered by MOD on the advice of Central Vigilance Commission, in short CVC. It is pertinent to mention that on 25th of November 2009, the CVC in a meeting in this connection has observed
So this has created difficulties.
Yes.
Yes. 4th March 2009. That stalled the 4th phase selection process. Yes.
There was no recruitment rules for recruitment of unskilled workers in the company. CVC advised to frame, this was in 2009. Please take note of the date, 2009.
Where from?
No, just above that Roman 1. it is pertinent to mention that on 25th November 2009.
Yes.
But the ball has started rolling in 2008. The recruitment process initiated in 2008. CBC advised to frame the recruitment rules for all categories of employees in consonance with the guidelines or instructions issued by the DPE or DOPT and get the same approved by the competent authority. But pausing here for a moment, the company's stand before the Honorable Division Bench was these guidelines cannot have any manner of application to the company. Submission recorded, the Honorable Division Bench was persuaded to pass order on the basis of that submission.
This has no manner of application.
The appointments on compassionate grounds, that is death in harness category, should be done strictly in terms of the guidelines laid down by DPE or DOPT. In case of any problem in implementing the existing instructions in face of the High Court judgment, the ministry should be approached for necessary guidance. In no case should
But
the
this submission might have been made, Mr. Mujumdar, in view of the revised policy which was introduced on 27th August 2013.
But this is in 2009 scenario. But submission can't change as regards applicability of guidelines. Company has framed a policy in 2013.
New policy. Your contention is this: there is no much difference in between these two policies.
So, to take recourse to CVC for the purpose of applicability of DPT or DOPT guidelines in the affidavit in opposition to the writ petition filed in 2016, turning a volte-face to the stand taken before the Honorable Division Bench is not expected of an Article 12 authority. In case of any irregular appointment, the same will attract vigilance angle and consequential actions by the
Which
vigilance
paragraph?
authority.
Yes. Paragraph 3, right.
Paragraph 4. Sorry, I'm paragraph 3. In case of any problem in implementing the existing instructions in face of the High Court judgment, the ministry should be approached for necessary guidance. In no case should the existing guidelines in the government be violated. But please keep this in mind. I'll show to your lordship, not the stand taken before the division. In case of any irregular appointment, the same will attract vigilance angle and consequential actions by the vigilance authorities. No further recruitment should take place unless proper qualifying criteria and guidelines are formulated and approved. Institution of case. Since in the fourth phase, the total recruitment process has been stalled, a writ petition was filed by 151 dependents of the deceased employees of the company for their recruitment, and the same has been registered as WPI so and so. In the said writ application, MOD has also filed an opposition before the learned single bench contending inter alia that the minutes of meeting dated 11th May 2006 cannot be treated as an agreement, since the same does not have the approval from the board, and as a consequence thereof, the same is not enforceable. But that 2006 memorandum of or the minutes of meeting which was laying down the criteria. It was further observed by MOD that the said MOM suffers from serious infirmities and the same is in gross violation of the DOPT office memorandum of 1988. The details
appointments were made in 3 phases to the extent of 170. Yes.
As we have tried to learn, respondents cannot challenge their own order or action. It is for the other side to challenge. Today, you have acted on the basis of the panel. Appointed 170 out of 249 already. You introduce a policy. Today, I am not troubling your lordship with the proposition of law propounded by the courts on compulsory appointment, which rule will apply. But you have acted upon this policy, appointed 170 out of 249.
Thereafter, you have recanted.
And you change this in the midstream of a process.
By introducing a policy dated 27th August 2013.
When the recruitment process was initiated in 2008. Now, the special bench has decided the issue in the Honorable Supreme Court. Which law will apply? Even in the process of recruitment. The earlier rule will apply.
That is culminated into Canara Bank's.
No, that is on compassionate appointment.
Yes, I am.
That cause title is, না না যেটা ওই ইয়েতে না যেটা ওই থ্রি জাজ বেঞ্চ যেটা বললো না যে ইয়ে
এটা হয়নি তো
হ্যাঁ হয়ে গেছে তেজ প্রকাশ পাঠক
because it's not on compassionate.
no not on which rule will apply
Tej Patak is not on compassionate.
not the matter
That is
was
not on compassionate appointment.
no, the issue was pending before the Honorable Supreme Court before the larger bench since 1992.
Yes.
Whether the rules as on the date of initiation of recruitment will apply or the change rule will apply. That came to be decided in 2025 to SCC page 1, holding that rules, altered rules will not apply or rules of the game cannot be
But
changed.
whether that proposition can be
No, that's a
in
different.
in case of compassionate
No,
appointment.
that's different. But that proposition, that I say that when you have already rolled into a action, a process, now what is the defense of the company? I have brought in a new rule. Now, if your lordship applies this analogy, whether the rules of recruitment existing on the date of initiation of process will apply or the change rules will apply to the recruitment process. It can't be that for a section of employees, the old rules will apply, and for a section of employees under the same process, a different rule will apply.
When 170 has already been
appointed. ওই জন্য এসএলপিটা আনলে সব দেখাতে পারতাম। Now, when your lordship is observing that whether that proposition will apply in cases of compassionate appointment, but I shall be also relying on this proposition when the three-judge bench decides an issue and answers Tej Prakash, answering the reference that rules of the game cannot be altered or the goalpost cannot change. It's really a change of goalposts so far as the compassionate appointees are concerned.
In the midst of process, the rule of the game cannot. There are series of judgments on this line.
Yes, but not the
latest one is Tej Prakash.
Yes, because it was resting before the Honorable Supreme Court on a reference. This has been now answered.
So you will rely upon this.
I will rely upon that. A compilation of judgment away now. But I was placing that affidavit.
Yes.
But I had placed up to CA.
Yes. Yes.
B now.
Yes, CB, page 25.
The said writ application as aforesaid was ultimately disposed of on 13th December 2011 with following direction.
That is 2009 writ petition. Yes.
Under these circumstances, it is thus evident that the consideration of the petitioner should not be kept in limbo and infinitum. It is high time that the procedure resorted to for their recruitment through advertisement sees a logical conclusion. Therefore, this court is not in a position to go on giving time after time to the concerned officials to frame rules. Under the circumstances, this court directs the authorities to start the process of consideration of the case of the petitioners for their recruitment subject to eligibility and other recruitments being fulfilled by them. However, in view of the allegations made by CVC to the effect that they had received complaints regarding irregularities, this court directs that when the cases of the petitioners are being considered and on each such occasion, a senior officer of the CVC must be present to oversee each and every case individually. Thereafter, and subject to the satisfaction recorded in writing by both the officers of GRSC as well as by such a senior officer of the CVC, the respondent authority shall conclude the matter in accordance with law and within a period of 6 months from the date of receipt of a copy of this order. Not pausing here for a moment.
Yes.
But what is the spirit of the order? These persons had been kept in limbo for a quite a long period of time. I am turning down your request to await the framing of rules. I am turning down the respondent's request to await or keep the process in abeyance till the rules are finalized. You complete the process.
Only addition which was incorporated is that the presence of an officer of CVC.
Meaning thereby, you complete the process following the earlier rules.
But this order was appealed.
Appealed. I'll show to your lordship the stand of the company.
Yes.
So the specific stand of the officials was, please await the failing of rules. Court has not granted that. The Central Vigilance Commission preferred a mandamus appeal against the said order, which was registered as Mat so and so, praying inter alia for its disassociation from the regular participation in the recruitment process. The Honorable Division Bench by an order was pleased to modify the order of the learned single bench to the following effect. Accordingly, in view of the aforesaid consensus arrived at by the learned advocates appearing for the parties, we direct the respondent numbers 154 to 158 to complete the process of consideration of the case of the writ petitioners with regard to their recruitment in accordance with law within a period of 6 months from date.
Extension of time.
So 2011.
Yes.
Done on 13th March 2013. We record that it is also agreed by the learned advocates appearing for the parties that as far as possible an officer of the Central Vigilance Commission will remain present at the process of consideration as aforesaid. In the event the officer of the CVC will remain present at the process of consideration as aforesaid. The authorities will be at liberty to make periodical review of all the process of consideration and shall pass appropriate orders with the aforesaid directions. The appeal stands disclosed. And then the contempt application was filed. Let I skip over that contempt. Please come to the last paragraph of the order quoted. Accordingly, proceedings are dropped. It is open to each individual to assail the decision of the committee if they desire so in accordance with law.
Page 29.
CD, under paragraph CD.
Yes, CD.
It quotes the order of the Honorable Division Bench.
Yes.
But please see, on going through the above paragraphs from paragraph 14 onwards, it is clear that there was no deliberate or intentional acts on the part of the committee to delay the process, but on account of verification of several factual doubts, it took some time to consider the matter in terms of directions of the court. There is consideration of the applications in accordance with law as understood by the committee as per the report from paragraph 14 onwards. Since there is no intentional violation of the directions of this court, we are of the opinion that there cannot be any further action for contempt of court. Accordingly, proceedings are dropped. It is open to each individual to assail the decision of the committee if they so desire in accordance with law. Copy of the report related is annexed. Copy of the status report was also annexed. Then please come to the next paragraph, capital D. Recruitment up to third phase as per MOM dated 11th May 2006. Vis-a-vis disciplinary action taken against the officials connected with the process. So what principally stands out clear is, as per the MOM, which they now disown as a settlement, but they refer it to as an MOM, was acted upon. And up to the third phase, this recruitment had taken place.
To the extent of appointment of 170.
In the months of July and September 2012, disciplinary actions were initiated against 4 senior level officers at the instance of CVC and MOD vigilance for irregularities in recruitment of casual laborers. In connection with the recruitment process, the course of action taken against the said senior officials are to the following effect. Ex-CMD, government displeasure. Ex-director personnel, government displeasure. That's catching of backs probably. GMHR, reduction to 1 stage lower in the time scale of pay, that is 1 time down for 6 months. Minor penalty, not cumulative effect, so minor penalty. AGM, reduction to 1 stage lower in the time scale of pay for 6 months. It is pertinent to mention that out of 4 senior officials involved in the said contempt proceedings, alleged contempt numbers 2, but that's not very important. Please come to paragraph E. The board in its meeting of 1998 decided that that's a repetition of 2008 and 2014 scenario. Please come to EB. It is pertinent to mention that following discrepancies were also informed to the board at its 318 and 319 meetings held on 15 July 2014 and 31st July 2014 respectively. Signed or approved list of candidates of DIH cases prior to 31/3/2006 is not available. However, an unsigned list of 279 DIH cases exists. There are 194 entries in the registers maintained for DIH cases prior to 31/3/2006, which are not figuring in the available frozen list of 279. Out of the above list of 279 DIH cases, 235 are recorded in DIH registers. Remaining 44 cases are not from DIH register. Out of 44 cases, 24 already employed. There are 189 entries of applications in the DIH register after 31/3/2006. No, we are not concerned with that because we belong to the frozen panel prior to 31/3/2006. Financial condition of the family and whether there is any other earning member in the family which is the primary requirement for compassionate employment has not been verified. Now I'll show to your lordship the stand taken by the company through its affidavit, which is something else. Copy of the board meeting of 2014 is annexed. Formalization of compassionate appointment policy. In the month of February 2011, MOD directed GRSE to finalize compassionate, but it's probably once again a repetition of the earlier pages. 2011, the government had directed to finalize, then the division bench has decided, giving 6 months time, then 2013 August, this was finalized.
It's not required. Yes.
Please come to paragraph FC.
FC, yes.
Ultimately, on 27th August 2013, a compassionate appointment scheme has been formulated by the company. Broadly, the said compassionate appointment scheme as envisaged in DOPT guidelines, amended up to January 2013, contains the following salient features. Please take note, not referring to DOPT guidelines. Compassionate appointments can be made up to a maximum of 5% of vacancies falling under direct recruitment quota in Group C or Group D posts. The ceiling of 5% direct recruitment vacancies for making compassionate appointment should not be exceeded by utilizing any other vacancies, that is post quota vacancy. The family is indigent and deserves immediate assistance for relief from financial destitution. The request of compassionate appointment can be considered even where the death or retirement or medical ground took place long back, say 5 years or so. However, while considering such belated request, it should, however, be kept in view that the concept of compassionate appointment is largely related to the need for immediate assistance to the family in order to relieve it from economic distress. The very fact that the family has been able to manage somehow all these years should normally be taken as adequate proof that the family had some dependable means of subsistence. Applicant for compassionate appointment should be eligible and suitable for the post in all respects under the provisions of the relevant recruitment rules. Pausing here for a moment. But how does your lordship, on a cursory observation of this policy so-called, find a stark difference from the 2009 or 2007 proposition laid down? In fact, that was more emphatic.
That 5%.
5% is a cap. But so far as qualification and eligibility criteria are concerned, on a cursory observation of this so-called 2013 policy, your lordship will not find any difference.
No striking difference excepting this 5%.
But I go a step
condition.
further by submitting that the earlier policy or that earlier minutes of meeting laid down the qualification up to class 8. No appointment if there is an earning member. That was more prominent. Age, that was more prominent. The recruitment rules promulgated by the company on 29th March does not contain any discretionary clause.
Just a minute. Yes.
The recruitment rules promulgated by the company on 29th March 2013 does not contain any discretionary clause, and as such there was no scope for granting any relaxation save what is incorporated in the approved recruitment rules. Now this is discretion. Please come to the previous page. Previous clause. The request can be considered even where the death or retirement on medical ground took place long back, say 5 years or so. However, while considering such belated request, it should, however, be kept in view that the concept of compassion is largely related. This is discretion. 3 phases of recruitment under MOM dated 11th May 2006 vis-a-vis major discrepancies occurred. It is respectfully submitted that during the course of first 3 phases of recruitment, following major discrepancies have come into light, and as a result whereof, being a public sector undertaking, the management is left with no other alternative but to formulate the policy for compassionate appointment in consonance with the law of the land. But how does discrepancy in finding out lead to a 5% cap?
Yes.
No recruitment rules existed for the employees at the material point of time. But what is the recruitment rule? Even today is unspelled. Casual labor is not an authorized post for the company. Not you are inviting, you are mentioning approved vacancies, appointing them first as casuals, then absorbing them. Now today you are saying that casual labor is not an authorized post.
After completing 3 phases of.
3 phases. As such, there could not have been an open advertisement for casual laborers citing specific vacancies. Then, if you have done so, you have exploited them.
Yes.
Meaning thereby, against vacancies, you have through advertisement, you have appointed casual laborers and paid them less. Now you put this up as a flag this up as a defense. Advertisement for the 4 phases of recruitment of casual laborers did not specify age and qualification required from the applicants. Who said so? They all acted on the basis of the 2006. Different eligibility criteria, that is with regard to qualification and age, were followed while considering applications in selection process for DIH and non-DIH applications. Had to be. What's abnormal in this?
Yes.
DIH cases have been taken with various relaxations in age, qualification, experiences, etc. against advertisement in 3 phases. Relaxation granted in age is in excess of what was not covered by any rule, including the judgment of the High Court in 1999. You yourself have decided to relax. In reality, age relaxation was granted to almost all DIH candidates, which was inconsistent with High Court order. But I fail to understand which High Court order. Violation of the 5% ceiling of DOPT guidelines on recruitment of compassionate appointments. Please take note of this. The stand before the Honorable Division Bench was these guidelines do not apply to the company.
Yes.
The said recruitment did not carry out verification of pecuniary condition in compassionate appointment cases, in spite of specific provisions of financial condition existed in MOM dated 11th May 2006 clause 5B. So for one purpose, the MOM will be reckoned as a settlement. And for the rest of the purposes, it will not be reckoned as a binding precedent or to have any binding efficacy. Wherein it was categorically mentioned that employment will be provided only if there is no earning member in the family of the deceased to support the family. Verification of financial condition is a precondition of any DIH recruitment. Applications of DIH candidates not selected in first phase were revalidated and considered in subsequent phases without further application against advertisements. The Honorable High Court in the said data application being WP of 1999 by an order of 7th August 2001 was pleased to hold that persons who have already applied and not got the employment, those will be given priority by the respondent company. It was not complied in letter and spirit as the names of the DIH applicants which were entered in the DIH registered maintained in the company were not taken into consideration for appointing on compassionate grounds. Appointments made were not in conformity with strict seniority. Two cases, it was not complied in letter and spirit as the names of the DIH applicants which were entered in the DIH register maintained in the company were not taken into consideration for appointment, and appointments were not made in conformity with strict seniority. Board directed not to recruit any unskilled category of workmen. Certification of the union regarding the dependents of the deceased employees. It is stated that although there were major discrepancies in recruiting the DIH candidates up to 3rd phase of recruitment process, the management purely on humanitarian ground and on a practical approach does not want to take any step reopening the issue. save what are matters of records, the statements made in 1 to, then not, it goes on to deal with the cases as pleaded in the writ petition. Now, for the time being, please come to quoted paragraph 6. But within quotes, it is paragraph 6, cases of compassionate employment, has your lordship got probably on the next page.
Paragraph 6.
41.
Well,
Page 40.
after paragraph, in paragraph 20.
Page 41, I think.
In paragraph 20, it is quoted.
It
Yes, page 41.
It is used.
I don't know. It
Cases of compassionate employment of dependents
Yes,
of
please come to paragraph 20, the
paragraph
20, 20.
20. Yes, paragraph 20, page 40.
The contentions put forward in paragraphs 3, 4, and 5 of the said application are misconceived and hence denied. The projection to
But
the effect,
in paragraph 20, paragraph 6 is quoted. Yes.
The projection to the effect that the document dated 11/1/97 to be an agreement is an incorrect one. The previous paragraphs all deal with the 1997 criterion. They proceed on the basis of this. Then they say that 2006 MOM was not considered. So far as the said minutes of meeting is concerned, there is a specific clause that such recruitment was subject to the approval of the board. The material portion of the said minutes of meeting reads as follows. Cases of compassionate employment of dependents of operatives died in harness would be processed as per the minutes after the same has been received the approval of the board. It is pertinent to mention that the board of directors of the company in its 224th meeting held on 1998 has imposed a ban on recruitment in the unskilled categories, which is subsisting at present also. So far as the contentions put forward in connection with the vacancies are concerned in the unskilled category, there is no vacancy in the respondent company wherein anybody could be accommodated. The petition numbers 3 to 51 do not possess any technical qualification based on which they can be accommodated in the skilled trade of operative cadre, and as such the general vacancy as has been projected in the chart being annexure P4 is of no consequence. But appointed on casual basis, given training, then absorbed. Basically, under unskilled operative cadre, following trades are there, out of which there is no requirement for engaging any person at present. But you notified the vacancies, you invited the process. It is fundamental that recruitment is always correlated with the requirement of the management and not otherwise. You initiated the recruitment in 2008.
Yes.
Now please come to the chart. Essential qualification.
Chart page 42.
Yes. There is a
skilled
column unskilled.
Yes.
Please see past class 8.
Yes.
So how does it materially differ from the earlier one? Up to serviceman 4, it's class 8.
Yes.
No, serviceman 4 lekha ache.
Serviceman 4, etc.
Serviceman 4.
Yes.
Serial 6, but the designation is serviceman 4. But then they once again say that there is a ban on recruitment. But please, pausing here for a moment. When it comes to a challenge thrown to an action, the stand taken is there is a ban on recruitment. Who initiated the process? You yourself decide to fill up posts. Is it open to you to say that there is a ban on recruitment now?
After recruiting 170.
Yes. Then please come to paragraph 22, the first subparagraph. I place paragraph 22 in its entirety.
Yes.
With regard to the contentions and allegations put forward in paragraphs 9 and 10 of the application, it is stated that journeyman grade is a skilled one and there was no ban on such recruitment, and as such, No illegality has been made by the answering respondent in appointing any person in journeyman grade. There is no operative post in the company. It is basically a cadre under which various grades are there, like unskilled, semi-skilled, skilled, skilled 2, skilled 1, highly skilled 1, and chargeman. So, operative is a cadre under which there are unskilled posts. But I don't know whether your lordship has ever come across in your lordship's career on this side as unskilled being a post. Skilled being a post. The ban on recruitment imposed by the board relates to unskilled category of operative cadre. But now these semantics come up. The letter dated 31st March 2005 is nothing but a communication of the said fact to the petitioner union.
Yes.
Save, not paragraph 23. Save what are matters of records, the statements made in paragraph 11 of the application are of no consequence and hence denied. No bipartite settlement has been arrived at on 11/5/2006. The first stand was 11/5/2006 in clause 5B said that there has to be an examination of the financial penury. How? If there is one person already appointed in the family, don't appoint anybody. Then they say 11/5/2006 is not a settlement. As wrongly contended in the paragraph under reply. It is nothing but a minutes of meeting which has got no enforceability before the Honorable Court in our jurisdiction. It is stated that since the same is not a settlement, rather a minutes of meeting without having any statutory force, the same cannot be enforced in a writ jurisdiction by praying a mandamus on such basis. No right, not to speak of any legal right, can be created in favor of the petitioners on the basis of the said minutes of meeting, especially when there is a ban on recruitment in unskilled category. Moreover, in paragraph 18 of the foregoing affidavit, the answering respondent has depicted the true picture about the illegality committed in recruiting the persons belonging to died in harness cases in unskilled category up to third phase and the consequence thereof suffered by the concerned authorities of the management, which include suffering the wrath of MOD as well as CVC in connection therewith.
So therefore, no recruitment, no further.
The contentions put forward in the paragraph 12 of the said application are incorrect and hence denied. The advertisement being annexed P9 referred in paragraph under reply does not indicate fourth phase of recruitment for the post of operatives, including persons belonging to died in harness category. The plain reading of the said advertisement indicates that the respondent company invites applications
on facts. Anything more you want to submit? These are the facts.
But I was just trying to show to your lordship the defense of the company. But I've from the list of dates I had shown what was my case. I'm trying to show the possible defense that the company may set up. And that's the stand on record. I only need to show to your lordship on the next date, but I had that SLP documents been there, it would have been easier for your lordship to go through the company's stand before the division bench straightway. But I just read that
So you want to show the stand of the company before the division
bench. But I just read this.
So that today you are handicapped because
that compilation is not before your lordship. I just read that paragraph once.
From the list of dates.
Yes, but I just I read from my copy. But
yes,
I don't dare to hand it up because it's heavily marked. The SLP copy is heavily marked.
Please don't. You'll be paying service to me. Very well, Mr. Mujumdar, come back on Friday at 3. Friday at 3.
After the next week.
No, let me hear, Mr. Mujumdar, your junior will be there. I will hear you there.
Friday onwards, I'll not be there. That's why.
Thursday, there is already a fixed matter. Mr. Mujumdar is appearing at 3 p.m. Tomorrow, interest matters are taken up from 3:30. So that's why
I know to what extent and for what purpose.
Mr. Mujumdar, since in a time-bound manner, the issue has to be heard out. So
I don't stand in the way because after all, these are compassionate appointments. Obviously,
I will hear you. whole hog, no issue. But let Mr. Mojumdar concludes his submission. Let it be on Friday at 3. I believe I don't have any division bench on that day. If it is there, there will be to be mentioned here. I don't think any division bench on Friday. Your junior will be there. If Mr. Mojumdar will try to finish it off. Otherwise, another date is to be fixed.
But kindly do not keep it on next week.
Next week, very well. 16 and 17. Whenever any matters I am trying to fix on 16 and 17, not only this matter here, time is required. Advocates are submitting the no. Please do not fix the matters on those days. I don't know what will happen on those 2 days.
Also used to do that when Lordship was on this side of the path. First day when your Lordship gets the calendar, that's what happens. To me.
Programs are chopped out.
The dates are out.
Issue. Matter is heard in presence of the learned advocates representing the petitioners and Garden Ridge Shipbuilders and Engineers Limited. Shipbuilders and Engineers Limited. Stop. This is the matter for further consideration. On
SLP counter rejoinder একটা ইয়ে আছে
Part.
on 11th April 2025 as 3 p.m. fixed matter. Mr. Mojumdar, Mr. Kaur, 3 p.m. You will not be there. I'm fixing.
Kindly excuse me, you don't mind. Post will be there.
Yes.
But after that.
Yes, after that it will be after 20th April, 21st onwards. Yes. Will it be convenient if I fix it at 2:30? Because Friday 3 p.m. means
yes.
Virtually
There is a
half an hour.
high chance.
Virtually half an hour. 2:30? Yes, 2:30. 3 p.m. টা 2:30 করে দেবে 2:30 p.m. fix
কাউন্টার রিজয়েন্ডার একটা ইয়ে
এগুলো না গন্ডগোল হয়ে যাবে সব
কি হচ্ছে নিলে কি হচ্ছে সবই আমার গাড়ি চাপিয়ে দেবে কারণ আমি
এটা ওর সঙ্গে করে পাঠাবো